The members present here are Senator Tina Rose Muñoz Barnes, Senator Anthony Etta, Senator James Espaldon, Senator Tello Taitigui, Senator Adolfo Palacios, Senator Frank Blas, and Speaker Judy Wampat, and Senator Judy Gutherds is here, and I think she stepped to the back room, but she's here. So we're going to go ahead and proceed. We ended our session last night with the 4 panels, and the last panel was the 2 attorneys who basically gave their viewpoints regarding this bill. The Senator Spaldon did ask if it would be possible to bring back the Attorney General and the OPA to maybe bounce off some questions. So I haven't gotten a follow-up to that request from Senator Spaldon. Senator Spaldon, did you want the Attorney General to come back in?
Yes, Mr. Chairman.
Okay. So with that, we'll just take a 1-minute recess, and we'll ask the Attorney General to come back in. He's already been sworn in, so that still holds, and we won't need to go through that again. We'll recess for about 2 minutes. This committee of the whole will now come back to order. Senator Espaldon.
Thank you, Mr. Chair. Good morning, Mr. Attorney General. Thank you for coming in. You know, the reason why I had asked that you be present and be allowed the opportunity to speak again after you were brought in yesterday is because we gave two attorneys an opportunity to speak to the issue of what's before us in terms of the bonds and how we can resolve this JFK funding procurement issue. Now, there was one gentleman in particular, Attorney Brown, who came in and actually, stated at the front end, he said he comes in basically as in good faith with no real involvement with any of the parties to the building of JFK. His expertise is more on the procurement law issue, and he kind of gave us a warning that, again, the integrity of the procurement law must stay intact, and if we do entertain and pass a measure such as one that is before us right now, that could possibly constitute a major change to the RFP. So I guess my first question would be, and I know you put enough lawyers together in a room, they could come up with different perspectives and whatnot. I would like to ask, what is your perspective on that? Would it constitute a major change? Would this legislation constitute a major change to the RFP that was put out that would open up the doors perhaps for other protests?
Thank you, Senator. I've had the pleasure to work with Mr. Brown over the years, and sometimes with regard to procurement, and I do respect his opinion. However, in this regard, I don't necessarily agree with him. I did bring the legislature some information. I have available to the legislature a listing of what's called the offerer register. And why that's relevant is because in our procurement law, protests are only available to certain persons. If you're not among that group of people who can protest, then you're just not available to do that. And one of the groups of people who can protest are, of course, the offerers. And there are 3 offerers. But also, the list of potential protesters includes those people who we would refer to as prospective offerers. And those prospective offerers are those who took the trouble to receive the request for proposal and take it away, and they signed up to do so. And so I have that list of who the prospective offerers are for the legislature, and you're welcome to have that, because this is the universe of people who are available to possibly protest. The statute says, in fact, excuse me, Senator, I'll find that. Any actual or prospective offerer or contractor who may be aggrieved is able to protest. So there's a specific universe of people, and it's the people on this list. The other thing, the reason why I disagree with Mr. Brown is because if we were opening up the offer, if we were making it possible for IBC or one of the other offerers to do more or different than was actually originally requested in the RFP, I agree that someone who didn't know what they were going to be able to do could be considered aggrieved by this. But we are eliminating a remedy. We are making it more difficult for offerers to be compensated in the future in the event something goes wrong or there's a legitimate claim made. This isn't the kind of thing that's going to inspire someone to say, gee, I wish I was in there now, because they're now making it more difficult for me to get a remedy. I just think logically it doesn't follow. Theoretically, oh yes, maybe that's possible that an offerer or a prospective offerer is going to say, I would have jumped in there if I had known there was no remedy. Follow me on that, Senator? Do you understand why it doesn't make any sense that somebody's going to say, I should have been allowed to be involved in the procurement that limits the remedies down the road for someone who protests?
I do follow
Okay.
you, and thank you for that
And
explanation.
so, but if you want to know the 8 or 9 different organizations that are prospective offerers, I've provided that information to the legislature this morning.
Okay.
Okay.
I guess the next question then would be that, again, Attorney Brown did say that perhaps there's a different way to achieve the same end of what we're trying to accomplish, other than the way this bill proposes. Bottom line, he was saying that if we formulated some kind of amendment to the law that would allow for the declaration of intent to award, and during that period of the intent to award, or with that announcement of the intent to award, would also follow the ability to disclose what is in the proposal from the offeror. That way, it opens up the 14-day window for any protests to be made, and during that 2-week period, that 14-day period, that then we can basically see if there indeed will be any protests. And if there are none, then the bond counsel can then give an unqualified recommendation, I suppose, I forgot what the terminology is, to the bond people out there, right? That would basically secure their comfort with what we have to offer. If there is, he is saying, of course, if we go down that road, there is always that possibility within that 14-day window that there could be a protest, and that would at least, if anything, shed light on any potential problems they may be in, and it would have to still go through an adjudicative process in terms of a determination of whether the protest has any merits or not.
That's right.
Do you have any perspective or thoughts on that approach?
Yes.
Thank you.
I once again disagree with Mr. Brown's analysis, and for several reasons. First of all, I don't think the legislature can or should be in the business of declaring an intent to award. That's not a legislative prerogative, that's an executive prerogative. So if there's going to be a declaration of any intent to award, that's really in the realm of the government and the governor's appointed purchasing agent to do.
But, along those lines, if I may just interrupt right now, if the legislation allows for the governor to do that.
Okay, so that's fine. We can do that now, Senator, and in fact, we've in effect done that. Declaring an intent to award is almost a legal non-event. It doesn't do anything, it doesn't trigger anything. The real substantive part of Mr. Brown's suggestion is to, in some way, make it okay to reveal the deal that's being negotiated or has been negotiated with International Bridge Corporation.
Right, from which a basis for protest can be formed.
Couple of thoughts, if you'll allow me, because I think this is important. First of all, the public auditor has already seen the deal and vetted it. So that Mr. Brown suggested nobody's seen it, nobody's given it the light, the bacteria grows except under light. It has been vetted by an independent party. It hasn't been vetted by the proposers, admittedly. Secondly, the government there's a reason why these proposals are not released until there's an award. And the reason is because let's assume that we did what Mr. Brown suggests and the legislature gave us permission to release this information. And for some reason, the deal falls through. And there could be any number of reasons, even though we're at the table trying to find the money. If the deal falls through, and proposer number 2 and proposer number 3 knows the deal, do you please appreciate what a difficult position the government is in to negotiate with anybody else after that. We then start from where we left off with proposer number 1 and negotiate from there. Do you think they're going to say, oh gee, I don't really want as much money as proposer number 1 wanted? just cut it a few million here or there, and we're good to go. No, it's like, I need more than proposer number one bargained with you. One of the reasons we don't give away that information is to allow the government to bargain with proposers on a fair and even field. So no, I don't want to give the information away, not just because the law doesn't allow me to, but because as the attorney for the government negotiating this deal, I don't want them to know what we've negotiated. It's none of their business. And if I have to go to number two, I sure as am not going to let them know what I already dealt with number one. We're going to start from where we started with number one with number two and go from there. So do you appreciate that the potential of spoiling the deal for the government is in giving that information up?
I do appreciate that.
Understand that the public auditor has vetted it. Now, I admit that there's something that someone else who's got an interest in this project may see that the public auditor didn't see. But I don't think we want to give up our advantage provided to us in the law to negotiate fairly with people. We get to hold some cards in our hand and we don't have to reveal them, Senator. I don't want to reveal them, and I would ask you as a matter of policy not to reveal them.
I appreciate that answer.
Thank you.
The other...
Senator, can I catch you in the next round?
Yes, thank you.
Okay.
Thank you, Mr. Chair.
Senator Palacios, did you?
Thank you very much, Mr. Chairman. I listened intently the line of questioning by the last speaker, and I have the same interest in that. The RFP is already out, and the RFP, of course, embodied the conditions and the terms that would determine the qualifications for the bidders. Now, this bill, in my understanding, is that it will alter some of the terms and that conditions. And so I have a listing here of people who pick up packets and probably did not turn in. Now, I would say that if this bill is passed as it is, then I would say that any one of this would have standing to challenge on the basis that had we known that this would be the provision which was never contained in the original RFP, then we would like a shot at it this time around. So could we do a rebid? Is that a logical conclusion? I mean, would any of this have a right then for a redress on that basis?
Thank you, Senator. Senator, the law provides for and allows for modifications of the request for proposal during negotiations based on certain things that arise in the course of the negotiation. They can't be, you can't make changes that will make it, as I said, there are some things you couldn't do because if proposers had known that, they would have been at the table themselves. This isn't opening it up further and making it more attractive, Senator. This is closing it down and making it less attractive. We're taking away something that people thought they had.
One moment, let me comment on that.
Well, and we're doing it on the basis of the reality of this proposal as it has gone forward.
Yeah, let me comment on that. On your comment that it makes it less attractive. How can it not be attractive when now I am the so-called uninterested bidder after all these things? How can it not be attractive when now I know that any bid that come across is uncontestable?
It's not uncontestable.
It is. I mean, or at the minimum, it would allow to proceed with definitely, if there's any problem while the construction is proceeding, pending all these other things, then the contractor that proceeded, notwithstanding that there is grievance and so forth, would have full recovery of what expended up to that point. To me, that is a benefit. That is an enhancement.
Senator, no one has said offerers who don't get this bid are going to get full recovery of what they spent. If you think that's what I testified to, allow me to clarify. I said to the legislature that may be something that would be available if a court decided to do that.
It would be available.
No, it wouldn't be
No,
available.
no, I'm saying it would be.
Well, I'm saying to you that it might be because judges can do what judges do, but the statute says very clearly that it isn't available. The statute and the RFP state very clearly that offerers' costs are not recoverable. That's what it says, Senator. Now, would a judge order otherwise? Possibly. But that's not in this bill, and that's not what's being proposed today.
I disagree with your comment that this would make it more restrictive and diminish the benefit. In fact, it would enhance the benefits. Thank you, Mr. Chairman.
Well, thank you, Senator. We just disagree on that, and I respect your position.
Thank you very much. Senator Antonietta?
Thank you, Mr. Chairman. Mr. Weisenberger, I know yesterday we touched a little bit about this legislation here. Just for re-clarification again, this piece of legislation does it in any way favor one bidder over the other, or is this a level playing field type legislation that if bidder number one wasn't able to, it'll be available to bidder number two and also to bidder number three should bidder number two fail?
In my opinion, Senator, this applies to all of the offerers equally. If one offerer has an advantage over another, it's simply because their offer was evaluated higher than another. And so this amendment would apply equally to any of the offerers if they got to the point where offerer number one is at right now.
So then this in no way would undermine the original RFP in any way?
In my opinion, it changes the RFP to some extent because the RFP refers to the procurement law and it refers specifically to this act. And so the offerers going in and the prospective offerers did not know this was going to happen. It is a change. I'm not denying that it's a change. I don't believe it's a change that changes the deal to such an extent that it needs to be re-offered. I disagree with the commentators last evening who felt that. That's my opinion, Senator.
Thank you, sir. Thank you, Mr. Chairman.
Thank you, Senator Etta. Senator Guthertz?
Good morning, Attorney General and colleagues and everyone.
Good morning.
You know,
Senator.
I've sort of been grappling with this since yesterday. And there appears to be good intentions involved. But unfortunately, the perception of the public, and I've been around since yesterday, meeting with people, and including the business community, they're really outraged about this possibility of passing this bill with a provision that basically would negate the ability of any entity to challenge this process for this particular project. And although it seems very simple to do this in order to expedite this, you know, in my heart I know there's a right way to do things and a wrong way to do things. And I cannot reconcile this. You know, Attorney General, I chair the Committee on Ethics and Standards for the Legislature. And our committee has a motto. And the motto is, where wrong is never right.
I'm sorry, where
wrong is never right. And although technically this might be okay, ethically, my instinct tells me it's not okay. And I'm having great difficulty doing something like this because, like many other senators here, they've always prided themselves on transparency and openness and communications and supporting the ability of people to ask questions and challenge government if they feel government is not representing them well. So I'm having great difficulty reconciling this with what this bill says. And of course I can't speak for others here. But for me, this is a problem. It doesn't feel ethical to me. And it appears that we're stretching the law to accommodate an interest, one interest, which may not be in the public interest. And I just wanted to say that. Thank you very much.
May I comment, Senator? Senator, as the Attorney General of Guam, the only interest I'm trying to accommodate is the government's interest. The government has passed a law to build JFK, and that's the only interest that I have, but I certainly respect your feelings. I don't have and would not express any such feelings to the body here because that's none of my business. I'm just trying to answer your legal questions.
Thank you, Senator. Senator Tenorio?
Thank you. Good morning, Mr. Chairman. Thank you, John, for joining us again today.
Good morning.
You know, Mr. Chairman and General Weisberger, we're looking at legislation, and as I listen to my colleagues' statements, I have to remember that my understanding of us being here is trying to build John F. Kennedy High School with a appreciation for what you said yesterday, and from what I've heard this morning, I just want to ask a couple questions that came from previous statements. Yesterday, you told us, and I want to be clear about what I heard, and maybe if I'm wrong, then tell me. You said yesterday, nothing here prevents a protest from being filed after the award. Is that correct?
That's correct. That's my understanding of this proposed bill.
Right. And you are the Attorney General, and again, I told you yesterday, we put a great degree of stock and credibility in the words that you give us because that is your responsibility, is the reason that you're here, is to make sure that we understand that
That's right.
your opinion as the Attorney General is to, in fact, give guidance to the government, and the interest of the government and the people of Guam is to build John F. Kennedy High School. And that is the purported view and the end result of passing this legislation. So, one more time, will this bill bar anyone from filing a protest for the process under which this John F. Kennedy High School is going to be built?
Well, among that universe of people who are allowed to file a protest,
Right, which are 3 people.
well, no, there are actually, and I
Well, the 3 bidders at least.
there's 3 offerers, and then there's a number of people who are what would be referred to under the law as prospective offerers who might be able to file a protest. They'd have to be aggrieved by some action taken in the course of this procurement. But it's my opinion, Senator, that this bill does not restrict or deny anyone the opportunity to file a protest who has the legal standing to do so.
Fair enough. So would it be fair to say then that this bill negates the ability for a protest to be filed?
No, it does not.
All right. Now let's talk about transparency. The public auditor and yourself testified yesterday about the process under which this was reviewed and the 2 other offerers, and essentially that the protests were filed by the 2 offerers, and as a result of that, they were vetted out. The process went to court, and that was basically articulated in the governor's letter to us. Correct?
That's what I don't.
Did you see
Not
the
sure
letter
what-
from the governor?
I did see the letter from the governor. I haven't reviewed it since yesterday.
Okay.
But what you said is correct. There were 2 protests. They have been resolved, and there was 1 appeal of a protest to the Superior Court. That's been resolved.
In your view, in your opinion, has there been any violation of transparency with respect to any of the processes?
I'm not sure what you mean by transparency.
What I mean is, Has there been any, in your opinion, from the review that you've done of the material and the law and the process, has there been anything non-transparent? Has there been anything shady? Has there been anything that's been inappropriate, unethical, as one of the previous comments came?
No, one of my jobs, Senator, at the Attorney General's office before I became the Attorney General was to review contracts and procurements, and usually from just the paper involved, so that before we would ask the Attorney General to sign a contract and send it on to the Governor for signature, I had to determine whether the procurement was done correctly and whether or not the contract and the legality of the words were all correct. And that's what I did. And so I've done that a number of times. And this body knows that with regard to one particular procurement involving the John F. Kennedy school program, when the Attorney General found that the procurement wasn't done correctly, we refused to sign the contract because the procurement wasn't done correctly, even given that school children might miss their meals the following day, et cetera, et cetera. So I only mention that because I want you to appreciate that we've taken this serious. My review of this procurement is that there was no shady deals, there are no tricks being played. Not only is the government acting appropriately and upright and in attempting to carry forward a complicated procurement, but that the players involved, both the offerer that we're negotiating with and the other offerers, have been, as far as I can tell, above board. They're trying to pursue their interests within the law and appropriately. But you must understand, as I do, that the government, meaning the Department of Public Works and JFK and GIA, they of course have an interest in accomplishing what the legislature has asked them to do. So they've pursued that assertively, as they should. So has the other offers. But nonetheless, they've all done it, as far as I know, within the rules that we've given them.
Thank you, Mr. Chairman. I just want to make sure that as we proceed in discussing the merits or the lack thereof of the legislation in front of us, that that when things are cast, whether it be about transparency, ethical conduct, or statements of whether or not it's in fact something that can be protested or cannot be protested, I think it's in my interest, at least, as a member of this body, to make sure that we get the opinions of the experts and those in a position of responsibility, such as the Attorney General, to clarify his views, because that's why they're here ultimately anyway, for us to make a decision based on the input provided by the panel and the committee of the whole. Thank you.
One comment, if I may, Senator.
Please.
Senator, if I thought there was something illegal here, I have not only a legal but an ethical obligation to advise this body and to advise formerly the Attorney General. I would be breaking the law to give you an opinion on this that I thought was incorrect. That isn't to say I couldn't be making a mistake. I could be, but I'm not allowed to tell you something about this legally that isn't correct.
Sure. Well, I don't think anyone's looking for perfection. I think we're looking for an forthright, honest assessment
Yes.
of the legal principles and the policies which you are empowered to oversee and to advise the legislature in your capacity now on the appropriateness, the relative ethical standards that you perceive them to be, even in your own position, and further whether about the transparency or the lack of the ability to protest this. Because as I hear these things, I want to make sure that when things are thrown out, that there's a little bit more to it than simply throwing something out on the floor and casting aspersions about the ethical transparency or the ability to protest without any evidence or anything that will effectively give me reason to believe there's credibility to those words. Thank you.
Mr. Chairman, point of information.
Proceed.
Yeah, thank you. I want to clarify something, if I may. What I said earlier reflects what my gut instinct is saying to me, that this doesn't feel right. And the reason it doesn't feel right is because this bill contains a provision that says there shall be no protests
It doesn't say that, Senator, but okay, go, I'm sorry.
Well, the equivalent of that. Why do we need that provision then? If you said anyone can protest, any entity can protest, then why do we have to have the provision in this bill? Explain that to me.
Yes, I'll be glad to explain it to you, Senator. What it says is that once contracts are entered into by the government of Guam with whoever they enter into on this particular procurement, those contracts shall be enforceable and may not be abrogated by a court somewhere down the road. This is a guarantee to bond to people who are going to loan money for the building of JFK that these contracts are going to be enforced. That's what it is. It doesn't say anything about protests, and protests aren't involved in this legislation at all. And if somebody suggested they were wrong.
Excuse me, Mr. Attorney General. The language in the bill.
That's a point of clarification you're saying. Senator Tunor is not done yet, are you?
Oh, okay. Well,
Okay, I'm sorry.
at any rate, Mr. Chairman, that's what I cannot reconcile, that provision in the bill. That's what I was referring to in my comments. And I want to make that clear.
So we will get back to you, Deb.
Thank you,
Thank you. At this time, I would like to recognize Senator Tariwe.
Thank you, thank you. Good morning again,
Good morning,
Attorney
Senator.
General. And I know you're in there doing a good job for the government of Guam, and I hope right beside government of Guam you say government of Guam and the people of Guam, their best interest. There's really a fine line to that. Most people would think so. You know, the government and the people. It's two different things. And it just seems to me, I hope you include that as well, the people of Guam, not just the government. But that was just an observation I just wanted to clarify.
Senator, part of my job is to make sure the government doesn't hurt the people.
Exactly,
Okay.
exactly. And,
That's my
and make sure that
responsibility.
so I do appreciate that last comment you just made. So let's just say now, as an attorney, okay, and the interests of everyone, and most especially the integrity that we put forth in our procurement process. What's so simple? I mean, it is so simple to just go through with this, go to the bond market, see if we can get the funding for this. And if it doesn't work out, then our next step is number 2, right? The provider for number 2. And if that didn't work out, then we go with number 3. I mean, that's the logical thing to do without jeopardizing the integrity of our procurement process, though I know it's important to build JFK. I do understand that. And it's important to build JFK. It was important to build JFK 2 years ago. But it's obvious that we've stepped on something right here. And we don't want to make the mistake of stepping on something again to even delay it even further. Now the process is moving forward. In your office, if we don't get the bond, as you mentioned early, with this first provider, or am I saying that correct? Provider?
Offerer. Offerer.
Offer, okay, offer that provides the service, but okay, offer, then we would move on to the next. Is that correct?
Let me clarify that,
But
please.
but if you can just answer my question, and then I'll let you comment. Is that correct?
Under certain circumstances, we can stop negotiating with offerer number 1 and move on to offerer number 2.
If we were unable to get if they were unable to get the funding, right?
They are able to get the funding, Senator.
Okay.
We're unable. This is important. And
So
I-
we would go, I'll
Oh.
let you finish. I'll let you finish. So the next step would go to the second one, right? Like you mentioned, and then the third, right?
This offerer has done everything we've asked them to do. The problem isn't with the offerer. The problem is with the government being unable to give the bond market what it's required to give it. It wouldn't matter if it was offerer number 1, offerer number 2, or offerer number 3. The problem isn't with the offerer. The problem is the government's inability to provide to the bond market what it needs to provide.
You know, Mr. Attorney General,
so
we've had
if we-
bonds that have been already issued out from GPA, COLA payments, and other scenarios as well. And if I may say, they have been very successful in being able to float these bonds. On top of that, for you to say that it's going to stop them, in the bond counsel statement yesterday, he had said that when going out to issue these bonds, a lot of it has to do with the ability of the government to pay it. But there is some credence to the individual, like the company that's up front with this. Now, if there's other opportunities or options out there, then there can be. But for you to say, it's solely on the government being able to pay solely 100%.
No,
that is a misstatement.
You're misunderstanding me. The government has to provide certain things to the bond market in order for the offerer to borrow the money, and we're not providing it to them. This deal has not been closed, not because of the offerer, anything they've lacked or are unable to do. And this is what I take issue with what was said last night. This offerer has done everything that they've been asked to do, and they were at the table, and they did have the money. And now we cannot give the bond market the assurance that we are by federal law required to give. And the language in this law, Senator, is just like the language in every bond indenture we've done. And that's what Mr. Dirk said. This language is in all those bonds. That's why we don't have a problem with the bonds, and it isn't in this. And until we put it in this, it isn't going to be able to happen with offerer 1, 2, or 3.
I appreciate that.
I don't want to argue with you, but I want to be clear on the law here.
Sure.
And if you want to disagree with me on the law, that's fine, but I'm just trying to help you understand the legal problem that we have.
Okay, and this was not offered or needed or brought up to the attention of this legislature at the very beginning of the issuance of an RFP.
That's correct.
Thank you.
Thank you for that. The next speaker, I recognize Senator Tata.
Mr. Attorney General,
Sure.
it seems that we're entertaining this bill in the interest of moving things along so that we can get started on the construction of JFK. And so, in listening to the discussions yesterday, I couldn't help but perceive that by passing this bill, it's going to take us down into another minefield. There's nothing right now that would, and maybe it's the same question that's being asked, and I probably need to hear it 10 different ways, 10 different times. But if by passing this bill, somebody could still lodge a protest, take this issue to the court and file a lawsuit. And what is the effect, though, of this bill? I mean, does it put a stop on everything until it is sorted out?
Well, I want to apologize to the legislature. I know I'm a little assertive this morning, but I sat through discussions last night that I think led you in a direction that was not accurate and was not correct. And so I have to try to clarify that so that you at least understand what the law is. What the legislature decides to do in terms of policy is up to the legislature. This is your responsibility and your prerogative. I don't, if you choose not to do this, that's okay with me. I don't think we're going to be able to proceed with this procurement as it's currently designed unless we fix a problem that exists. But it may simply mean we redesign it and start over. But that's a decision not to be made by me. It was said last night that there could be an injunction acquired. I think that's where you're going, Senator. Can I address that? I have some information about that. Just a moment. First of all, there needs to be a legal claim asserted. Let's assume, for purposes of discussion, that the legislature passes this law. In order for somebody to get an injunction or a temporary restraining order and then an injunction, and basically to get a court to set this law aside, they have to find a legal problem with the law. The legislature has the authority to do this. So if the legislature does it, but it creates a legal, it does something that creates a legal claim for someone, then they can assert that claim in the court. So here are the possible claims as far as we've been able to figure them out. And I laid them out for the legislature yesterday. There might be a claim that it's an ex post facto law. Let's talk about ex post facto, if I may. Ex post facto is a constitutional protection that doesn't allow the government to pass a law that would mean that something I did yesterday is a crime today. Okay? It really relates to criminal laws, I think almost exclusively, although I'm not an expert on constitutional law, but to the extent that we understand this problem, ex post facto laws are laws that make it a crime to do something, and it was done before the law was passed, and we're now going to prosecute somebody for something that wasn't a crime when they did it, and now we're making it a crime. So it's not an ex post facto law. The Constitution also does not allow the government to pass laws that impair contracts. There's no contract. We can't impair a contract, there isn't one. The Constitution and the Organic Act do not allow you to pass a law that's going to violate the equal protection of citizens. I believe the law treats everybody equally. It treats the offerers equally. They're all getting the same pill, if you will, or remedy or benefit. It's just that one might get it before others. It's not a violation of due process because it's a rational thing for the legislature to do. That's the best way I can explain it. Due process is a complicated concept. I don't claim to understand it as well as I perhaps could or should, but if the legislature has a rational basis and it's in the interest of the people of Guam to do this, I don't believe it violates due process. That's my opinion. But let's assume somebody claims it does so, okay? One of those reasons. They can get a temporary restraining order, and they very well may be. A temporary restraining order is a type of an injunction that a court gives without a hearing for a very short period of time to stop things until the other party can come to court. And the standard is this: it has to clearly appear from the specific facts shown in the affidavit filed by the applicant that immediate and irreparable injury, loss, or damage will result to the applicant. And so, if they claimed a violation of due process, and if the court thought that there was such, the court very well may issue a temporary restraining order if it feels that it clearly appears from the facts shown that immediate and irreparable injury may result. Within 10 days, there's going to be a hearing. The government then gets to appear at a hearing, probably for a temporary injunction. Whether the temporary injunction is issued is in the sound discretion of the court. So the court has the discretion to do it, but again, it has to find that there is a basis for an illegality. They have to have some sense that the petitioner has identified some illegality with the law. It's an extraordinary remedy that should only be granted with the utmost care and should not be granted unless need is clear. So there's a high standard for the court in doing this. It's not done simply because they're asked to do it. It's done with the utmost care. The traditional, and I'm quoting from a case, the traditional equitable criteria for granting preliminary injunctive relief are: 1, a strong likelihood of success on the merits, and on the merits means that that illegality they're pointing to is in fact an illegality, and there's facts to prove it. A possibility of irreparable injury to the plaintiff if the preliminary relief is not granted. Irreparable injury, and this could qualify for that. There's no question if you're taking away a remedy from a offerer that might be considered an irreparable injury. And a balance of hardships favoring the plaintiff, advancement of the public interest in certain cases. Important that the court is going to look at whether there's an advancement of public interest in certain cases. That's where your language in the intent clause of this proposed bill helps the court to sort out whether you were just acting to help one person or acting in the interest of the government. And that's where one senator's concern about how she feels that this bill makes her feel is a concern. But, I mean, again, I'm just the attorney for the government. I'm not going to tell you what you ought to do, but the intent clause of this bill lays out what I consider to be a rational basis based on the public interest. The problem faced in this bill couldn't have been predicted at the beginning, or we might have put language like this in. We didn't think about it. You didn't. The Attorney General didn't. Nobody thought about this kind of a problem. We didn't anticipate it. After all, you'd gone through this before with the building of the 3 or 4 schools like a hot knife through butter. It worked very well. You thought it was going to work well again. Well, now we find out that there's a problem when there are protests. And so, and then after the temporary injunction, Senator, assuming it's granted, then there's a trial scheduled pretty quickly, probably within a couple of months, probably sooner, in which the actual merits, the court will decide for sure whether they were right when they granted the temporary injunction. And then it'll be a final order. And again, I can just give you my opinion. Could this happen? Yes. Do I think that there's a legitimate legal basis for this bill to be attacked subsequently? It's my opinion that there isn't a basis that, based on our research to this point. Will you all be able to say it's Weisenberger's fault when and if it happens down the road? Yes. You certainly will. He told us this wouldn't happen, and then it did. So it could happen, but all I can do is give you my best opinion and guide you as well as I can. And that's what I'm trying to do.
Thank you. If there's no other, I do have one more question, and that is on the point of on whether this bill gives an advantage, an unfair advantage to one party at the expense of others. And the response that I understand from you is that no, because it is equitable. Everybody can benefit from what the bill is offering. But then I ask, well, it gives an advantage to those offerers that require to go to that same bond market that's demanding a unqualified certificate, whatever it is called. But what if another offerer says, I don't need that. I got the money in the bank. I'm ready to go. So then, by giving the other 2 offerers then the advantage, I mean, how is that equitable for that guy who doesn't need that? So in essence then, The other two guys were actually given an advantage that benefited them, but was of no consequence to the other guy who already has the money. So can you just address that?
Sure. None of the offerers had money in the hand ready to go at the time that these proposals were evaluated. I can't say much more than that. I'm at a complete disadvantage to testimony you received last night from the attorney for one of the offerers. I can't comment about that because I'm legally bound not to comment about it. But I can say this: nobody had money in hand when they met with the evaluation team back in January of 2009. Every one of them had to go out and borrow money. Every one of them needed the government standing next to them, supporting that application, whatever kind it was. That's my understanding. That's what I've been advised. I believe that's accurate. If it isn't accurate, I'm going to ask Mr. Dirks to advise me, and we will correct the record. But I believe that every one of the offerers needed the GIDA to work with them to acquire money at the interest rate they wanted to acquire it at. A private borrower going to the market to borrow money without some kind of tax exemption would have had to pay much more for the money. You and I know that just based on our common knowledge, Senator. And so that's really where all of them were.
Okay, thank you.
That's my understanding. And again, Mr. Dirks, if you're there, and if I'm misstating this, please enter the chamber and we'll correct that immediately, because I don't want to misstate anything to this.
Thank you, Mr. Chairman.
He just ran out of the, no, he didn't. I'm just kidding. He's coming in, okay. Let's have him clarify that. Thank you. I have for the legislature this morning a list of the evaluators, so we can be clear who the evaluators were. The evaluation terms of the RFP. Mr. Leon Guerrero was not exactly accurate yesterday in his testimony when he told you he couldn't tell you what the evaluation process was. It isn't confidential, it was published. So I have it for you, if you'd like it, along with the list of the evaluators and the 3 court decisions. Well, the 2 public auditor decisions and the Superior Court decision, I have copies for the legislature if you'd like those. They're right here for you. It is true, as it was said last night, that the public auditor was critical of the evaluation process. You'll read that in her report. Nonetheless, she agreed that the evaluation process was within the law and the RFP. Thank you.
Mr. Chair. I just
Wait.
want to follow up on that question, just based on, because maybe I...
Yeah, you haven't spoken for the first round yet, not yet. So maybe I'll recognize you after
Yes,
after Senator Cao will raise, and then you, if you don't mind. Thank you.
Thank you very much, Mr. Chair. In fact, I'm just reading over the public auditor's report, and that's interesting. This thing has been and there is, and I would call it some uniqueness to it, because the complication from the very beginning, in regards to this is not a solicitation for bid.
No.
This is an RFP. So from the very beginning, statute-wise, this process for the RFP is differing. And again, the comments on the process of an RFP, looking at the evaluation criteria, and you know, there's been that issue on the ability to finance, or the ability of the lessor to structure a municipal lease. Well, out of the points, it's only 5% of the points for the, in the evaluation criteria. The other issue here, of course, is some of her strong statements in regard to the lack of due diligence by DPW and the groups that were involved in this evaluation. So there's a part of me, again, some of the comments made earlier about there are no villains here. I can see how this process has moved forward. Both 1, 2, and 3 have done their part. But because of how this thing has unfolded, number one, because it was done through an RFP process. Number two, because some of the issues in the evaluation criteria that were set up and the lack of potential of due diligence exercised by representatives of the government. You know, this is an issue which I think when you mix a recipe for a cake, but you put some of the put some bad ingredients there, some like eggshells, then no matter how good the baker is, the cake that comes out has a lot of part to do with how this thing was, the formula was set up, and the recipe was set up. So I understand this situation. I, for one, don't like doing selective legislation, particular to one issue. But again, this has been this particular situation with JFK and how things have moved along over the past few years, moving it forward. Guys, we got to look at ourselves too. The legislature and this administration. You know, there's a reason why we're having issues, and I'm going to stretch it, and whether it's a protest in the port or protest for other areas, and there's been some sloppiness. And now we've got to fix it because we have a bunch of nomads, and those are the nomads from JFK. I did have a question. This is my commentary, but now back to the question. There is the issue on the 19 million, and I don't know whether Mr. AG, you would be the one, but based on that was when it came down to it, that 19 million that was not explained, and I guess that would only happen and would only become apparent to the public after the award has occurred. So you see, because of this process, we're still kind of scratching our heads, and even the public auditor is scratching her head as to this 19 million.
Senator, the public auditor has been given the information. She testified to that last night.
Oh, okay. Okay, so that answer has been given.
Yeah. She has received responses from the Department of Public Works on all the questions she asked, all the requirements. She's received all those. Now, one she just realized last evening that she had received a couple weeks ago. That had to do with the cost of the maintenance agreement. But as to what and I'm going to say the so-called $19 million,
yeah,
she's received the explanation for why the cost has risen from what was originally proposed to what actually needed to be financed. She's resolved that. There are answers to that. They have been given to her. They are proprietary, Senator. I can't tell you.
But to the best of her, and I wish I had left the floor that night, but to the best of her knowledge, and whether, I know you're the wrong one to ask, but if you were there, so that she has, to the best of her knowledge, she was satisfied with that.
That's my recollection of her testimony, yes.
All right.
And of course, the legislature can ask her for that information again. But that's what she said, Senator, as I recall.
All right. Thank you very much. Thank you.
At this time, I'd like to recognize Senator Mona Barnes.
Thank you, Mr. Chair. Sorry about that. You know, I just probably wanted to follow up from Senator Tom Atta from Manila. When we look at the need for this amendment or this legislation as proposed to us, and of course the major concerns, Mr. Weisenberger, of where our sentiments lie, or at least for me personally, it's trying to further understand the differences of how the RFP was set out, where it came to play, how, when I asked the questions yesterday about the questions and the possibilities of improprieties or just questionings, and it went through the ringer through A to Z, and I asked the question, well, after all that was cleared, then why can't we move forward? And the answer was consistent, was that we need this, because if this bidder doesn't get this financing with the government, then we cannot move forward. Is that a correct statement?
The bidder can't get the financing because the government can't give the unqualified opinion.
Okay, but
There's
the
nothing wrong with
unqualified opinion is needed because the bond we are seeking for is tax exempt?
No, it's needed because, it's needed because it's a financing that will receive exemption from federal taxation, and there are federal laws that require that an independent attorney, albeit retained by the government, gives an opinion about the ability of the government to pay its obligations going forward.
So would that qualified opinion be needed if, take worst case scenario, this amendment doesn't go through, if the other two offers have alternative measures to move forward on this project?
They can only move forward on what they proposed. They can't create a new...
Well, didn't they have alternative financing when they went through the process that was offered on the table?
They had alternatives, but they've got to do it within what's in their proposal. As long as it's within their proposal, and whatever variations the government may allow them to proceed along to make it happen. But my understanding is that all the proposals required a tax-exempt type of financing, every one of them, and they can't come in with something really different, I don't believe. Then that would probably be a material change that would require us to
Mr. Chairman, point of information. There was this letter that was dated July 29th from the law firm of Berman, O'Connor, and Mann, and I guess he's representing GCIF, one of the offerers. And in his letter, in the third paragraph, he says, comments made during the hearing about GCIF's financing preparedness at the time of bidding the project are true. GCIF did in fact attend the bid proposal conference with Department of Agriculture representatives, and GCIF had already secured financing at the time of the bidding. I guess he meant at the time that the proposals were submitted. It was possible to secure financing at this early date because GCIF used a different method of financing the project, still meeting the requirements of Section 58A of Guam law. And Section 58A of Guam law requires that they go out and either get a tax-exempt or financing that's similar, whatever instrument is used, that would provide just as much a competitive interest rate. So I guess I bring that up as a point of information to kind of, I guess, get the comment that you made earlier, that they were all at the same point where they all needed to go to the same bond market, and all of them would have needed the unqualified certificate.
That's my understanding, Senator. I'd love to be able to tell you what actually happened and how it happened and where it happened and why it happened, but I can't. I stand by my statement. Mr. Berman and I apparently don't agree with each other. He's free to talk all he wants about his client's deal if he wants to. I can't talk about his or anybody else's deal and won't. But I will also point out that his offer was not graded as high as the number one offeror. I won't tell you which one they are. It doesn't matter. It isn't the party we're negotiating with. And let me clarify one other thing, because it was indicated last night that if we end negotiations with offeror number one, we must go to offeror number two. That is not true. That is a misstatement of the law. We may go to offeror number two. We don't have to. We can end the procurement process. There are certain there are certain provisions that allow us to decide that it's not going to work for any of the offerers, and there's a problem with the procurement, and we're going to end it. So it's not a shall go to number 2, neither in the law nor in the regulations. It's a may go to number 2. Now it is true, if we're going to go to the next offeror, it's got to be offeror number 2. And then if we cease negotiate, and we can't go back to number 1 once we've ended the negotiations with them, that we're done with them. We may go to number 2. And if we don't reach a deal with number 2, we may go to number 3. But we also may decide, and this is in the hands of the procurement officer, Andrew Leon Guerrero, to decide. But he does have to provide a written determination of why he's making that decision. So that would be required, and he would be advised by my office on what the law requires. But I want to clarify that. There's nothing requiring us to go forward on a process if we believe it's not going to work because we can't provide the bond market what they need.
Okay. Proceed, Senator Barnes. I think that was just a point of clarification.
Did I ever answer?
Yeah, I mean, you know what, maybe an even more understanding, maybe, I don't know, maybe, excuse me, Mr. Standergs can give a better clarification, because I thought that the reason why the need for this legislation was gravely needed was because in order for them to ascertain the tax exempt status and for us to go out with this, that clause was needed because they were going out for that tax exempt bonds. And I'm saying that if there was an alternative to providing alternative financing measures from the other 2 offerers, then shouldn't the government look into that? Because the authorization was already given. I mean, that's why you take the top 3 in some instances, or top 5 in other instances, and then you choose from there and you work the evaluations out. And I'm just trying to.
I think that my characterization of the criticisms of the public auditor, which Senator Calvo has discussed, and I've provided copies to you so you can read that, had to do with the way the RFP might have been designed. I'd like to remind you that you gave DPW 30 days to design a complicated RFP. That's how much time they were given. Get that RFP out in 30 days. They, I think, didn't quite meet the deadline, but they were pretty close. And then you wanted this process to go quickly, and a building built within 9 months from there. So they tried, and there were some problems with the procurement. It's laid out clearly by the public auditor, but it still was within the law. And then we will, one other comment. The number 1 offerer has come to the table with the money. It's not that they're not at the table with the money. We can't give the bond market what it requires. It's not the offerers who have the problem here, it's the government. There's no reason, apparently, this is Mr. Leon Guerrero's call, there's no reason to end negotiations with offerer number 1 and go to offerer number 2. It's as simple as that. They're there, ready, willing, able. We're trying to be there with them, that's all. That's the way I understand it.
Mr. Chair, I appreciate Attorney Weisenberger's comments, and I just know that we as policymakers have to protect the integrity of the RFP and moving forward. And yes, there may have been a lot of, I guess, confusion on the process, or the government not being able to, I guess, in a timely manner, set out the parameters needed because they probably felt rushed. But as a policymaker, the integrity of protecting that is in our hands. So I I understand the critical nature that you're in, and I appreciate the sincerity and the honesty, and I just know that I'm trying to find a resolve that I can personally feel that I can sleep with, knowing that no due process in this movement forward is in violation of any of the laws that we have implemented for the protection for the people of Guam, and that's where my conscience is at. Yeah.
And Senator, reshuffle the order of the offerers, I don't care. Wouldn't matter to me who number one is. I'm just trying to help the government carry out its policy
Obligation.
within the law.
Okay, thank you very much. We're going on a second round if nobody's interested for anymore. I recognize Senator Espaldon. Second round, sir. Proceed.
Thank you, Mr. Chair. Mr. Attorney General, one of our colleagues basically was making a statement earlier that we've done this before with no problems, and there have been no requests before the legislature to come in and pass a bill like this, which would limit the remedies in case a protest is filed. Right? Now, I just want to make sure I was certain that of what I heard yesterday. The only other time that we have gone down this road in terms of this type of approach to the financing with the true bonds and with the lease back and whatnot was with the 4 schools that were built within this past 4 years.
To my knowledge, that's correct.
And then I believe that's what legal bond counsel stated as well. So to compare the bonds that were floated for other infrastructure projects, such as GPA, GWA, and whatever else we might have had there, would be an unfair comparison to the situation now?
Senator, bonds are not procured.
Okay, excuse me.
And, well, no, this is an important clarification.
Right.
Bonds are not procured and do not go through a procurement process.
Okay.
The legislature authorizes the government to acquire funding or borrow money. They outline all the provisions. They give certain allowances, whatever the design is, probably a lot of which is predicated on what bond counsel says is needed. And then you pass a law, and then GITA goes out to the market directly for the government and borrows money. That's not a procurement. That's
Okay.
a borrowing.
That's a borrowing.
This is attempting to do a procurement where the offerer is going to borrow money, and if they're going to get tax-exempt money, the government must provide certain information to the bond market. So we're mixing, if you will, in a sense, the procurement code in with a borrowing, because we're asking the offerer to borrow.
And that is essentially the issue here. Is that your understanding?
That's why we have.
That's why we are here.
Whether we will ever be able to do this again and under what terms remains to be seen, now that we appreciate the dilemma that's caused by a protest.
Right, right. And then it behooves us as a legislature to at least take note now that if we go forward to attempt to secure financing through this methodology, that this situation may arise again.
I presume that you all will get assistance from GITA and the bond counsel prior to drafting the next piece of legislation if you intend to use this form of financing, so you can anticipate this problem and deal with it in advance.
Right. So bottom line, I want to get back to that original question. The comparison to the other bond financing that we have sought with this particular methodology is like comparing apples and oranges.
Yeah, it's comparing a borrowing, which is not a procurement, to a procurement, which has a lot of rules.
Okay, so that previous argument perhaps may not have as much weight as some might believe it to have.
That's for you to decide, sir.
Okay, but there is a difference between
There is a difference.
Okay, thank you. Going back to another question I had previously, there have been, you had stated that you may disagree or that you may might disagree on some issues that were spoken to yesterday by Attorney Brown. And I will mention my name because he was introduced by name, and that's exactly who gave certain things. Would those differences in opinion be cause for litigation? I mean, in other words, you get enough lawyers in a room, there's always differences of opinion, but because of those differences in opinion or perspectives, that really gives rise for a potential litigation.
It's such a general question, I'm not sure I can answer it.
Thank you. Then I'll pass on that.
I tried to be careful when I first responded to a couple of things that John Brown had suggested to the legislature. At the time I responded to them, I gave you my best advice as to whether I thought they were relevant and in what context.
Right. No,
but
okay.
he and I don't agree on that.
On certain issues
Yes.
along those lines. Okay. I have other questions, Mr. Chair. I'll wait for the next round. Thank you.
Thank you very much, Senator. Speaker Wampat? Oh, sorry.
Thank you,
Senator
Mr.
Palacios,
Chair.
did you?
Oh, I'm sorry.
She's
I have not,
Okay,
yes.
all right.
Thank you very much. I'd like to pick up where you had left off, but probably the only person that can really answer this question is bond counsel. And I can ask the question, unless you'll be able to answer the question, is that if all three offers had a plan, a financing plan, do you know if the other two offers in their, I know you can't reveal all these things, but in their financing plan are able to move forward, would they need an unqualified opinion?
The right person to ask is bond counsel. I believe he's here, but I think he's testified to that. I believe he's testified that that's correct, but I can't tell you why, and I wouldn't try to.
So can we ask that bond counsel please be brought in?
He did come this morning, I believe.
Mm-hmm. He's out there. Welcome back, Mr. Dirks. Speaker Wampat.
Do I need to repeat my question, or you heard me out there?
I believe I heard it. I believe the most direct, yes. I believe the most direct answer is to say that I believe that any financing that would comply with the statute would involve an opinion, the need for an unqualified opinion to the effect that the government's obligation was valid and binding. And that would be true whether it was a bank loan, an issue to the public markets of tax-exempt obligations, or a USDA loan. Let me tell you, the USDA is a tough lender. We've negotiated with them quite a bit, and they require opinions as well, including customary unqualified opinions of bond counsel. So I don't think that the need for an unqualified opinion would have been different in any of the cases.
So if I heard you correctly then, in simpler terms, in a layman's term, is that all three, whoever it is, if bidder 1, 2, and 3, that if they were to go before the bond market, is that they would all need to have this same language of an unqualified opinion for you to give.
On the basis of the information that's public about the proposals, and obviously I'm bound by the same principles as the Attorney General's office about revealing information about proposals, that is my opinion, yes.
And one more time, although we've been asking questions, trying to make sense of the language, and this is actually the language by yourself and the AG's office, I would like for you to do for us here is actually go down line by line and tell us, because we don't have your position paper as we asked originally, a written position on the language that both of you crafted. Can you please take us on page 2, line 20, 2B, and
Okay.
you know.
Sergeant at Arms, please provide a copy of the, oh, do you have a copy of that?
I don't. This is the existing
No, the bill.
statute, not the...
Yeah,
Okay.
the bill itself.
The copy of the bill.
Yes, and you know, in our, you know, for us to be able to understand this as laymen, we're not all attorneys, you know, here.
Okay.
Matt, you got any more copies? Yes.
So, starting with the legislative intent,
No, I think Stanley.
It's just
Or-
a 2B,
2B.
oh, just starting with 2B.
yes, because
Okay.
upon the execution and.
Okay. The first phrase, upon the execution and delivery by the education agency of the contract, the lease, and the lease back, and any other agreements relating to the design, construction, maintenance, and financing of the education facility. That phrase refers to a point in time that we would call the closing. And the closing is when the lease is delivered, the lease back is delivered, the underwriters pay, you know, we're guessing roughly $59 million to a trustee, and that money becomes available for purposes of implementing the project. That's what we call the closing. It's the delivery of all of those documents and the receipt of the money that's going to be used to finance the facility. So that first phrase, upon the execution and delivery of these various agreements, the contract, lease, leaseback, and such other agreements shall be valid and binding obligations of the education agency. That phrase says that the investors can rely upon those agreements. There is no challenge that will be permitted under the procurement statutes that would cause a court to say to investors, I'm sorry, you thought you had a deal, you paid us $59 million, but we are not able to stand by our deal. So that phrase is the phrase that would give investors comfort that a deal is a deal, and they paid us $59 million, and we will pay it back. That's what that phrase says. And that's basically what the rest of the section says as well in reinforcement. Enforceable in accordance with their respective terms. That's the notion, yes, we will live by our agreement to pay you back. Notwithstanding any proceedings under Chapter 5 of Title 5, that means even if a protest is brought under the procurement statute, that's the reference, to the contrary. In other words, even if a protester were to come and claim those agreements should not be valid for XYZ reasons. Now, we don't think that any protester would have valid XYZ reasons to make such a claim, but this statute would say even if they brought such a claim, the government of Guam and investors have a deal, and the deal could be relied upon by the investors. And basically the language in lines 7 through 12 of that page 3, upon the execution and delivery of the agreement, et cetera, it says the same thing another way. We lawyers are sometimes prone to that problem. We like to say things and then say them again in order to make sure that people understand what they mean. But again, it says that no procurement protest no proceeding under Chapter 5 of Title 5 shall be permitted to challenge the validity or enforceability of such agreements. That's, again, a statement that, there are many, many, many other laws that apply to those agreements. Lots of laws relating to contracts, government obligations, et cetera, et cetera. Those laws all still apply, but a procurement protest cannot be the basis for a challenge to the validity and enforceability of those agreements. I note, as has been pointed out before, that procurement protests can still be made. The light of transparent government can be shined upon these contracts, and all of the information that would be available in such a protest can be made available to the public. But the end result cannot be that the government would be permitted to declare, or a court would be permitted to declare, that the agreements are not valid. We would take away that one remedy because investors are entitled to the certainty that they will be repaid.
So the no proceeding is the procurement protest, and there's a statement you just said that the end result would be is that not even the courts then will be able to say that this contract is not valid.
Not as a result of a procurement protest, that's correct. Now, if we've done something else wrong, if we've not complied otherwise with Chapter 58A, for example, the law under which the obligations were authorized, a challenge could be brought under those grounds, but not a challenge under the procurement laws.
And line 11, where it talks about the agreement itself, but any other agreements. What are the any other agreements here that we're not privy to?
The other agreements relate to such things as the ongoing annual maintenance of the facility. We've broken down design, development, and construction of the facility into one agreement and maintenance into another agreement. So, for example, the maintenance contract, the capital maintenance obligation, is expressed in a different agreement.
On line 8, again, the no proceeding, and if the no procurement protest under, now this is very broad, under Chapter 5 of Title 5, then that's everything about Chapter 5, Title 5.
That's
all
correct.
Other sections.
That's correct. But again, protests can be brought under Chapter 5. The only thing that can't happen is that the agreements be declared invalid.
So, I mean, that is really open-ended. I mean, I understand when you specifically, like, for example, when you talk about on page 1, when you're talking about the, the retroactive effect, and you're very specific, of Section 7 of 2 of Title 1, but in this case now, you're actually addressing the entire procurement law.
Senator, Chapter 5 of Title 5 is the procurement law.
Right, so that's what I'm saying. So it's everything. So it's not just specific to, like, for example, yesterday you had indicated there were different sections of the procurement law where remedies can be, taken. So would this then, because of this then, that even the remedies that are listed in the law are not applicable? Yes, I mean, yes, I understand that, but now the question is...
If I may, it results in all of the procurement law remaining applicable except the ability to obtain the remedy of the declaration that these contracts are invalid. All of the procurement law stays intact except that one remedy.
Yeah, but where is that one section then that actually addresses that rather than the whole procurement law. Just that one section where, you know, you are able to award then the contract, I can see then amending that one section, but we're not. So this is, I mean, we're giving you full reins. It's like us giving you a blank check and you take it and do what you please with it.
No, because again, the only thing we've done is said that you can't use the procurement law to declare these contracts invalid or unenforceable. That's the only thing we've done. I mean, I wouldn't disagree with you that we could have drafted this differently and used different words. But what I'm telling you is that we have had a very narrow effect here, and that is that the only thing we've done is said that these contracts cannot be declared invalid under the procurement law. Under other laws, correct.
So Mr. Chairman, if there aren't any other questions, I'd like to make a motion then that we dismiss the panel and that the body would continue or proceed with its deliberations on the bill.
Senator Spaldon, did you still have questions?
Yes, I just want to make sure that, because I just want to make sure we clarify that last exchange, because I was not the questioner in this. And bottom line, what bond counsel has stated, and correct me if I'm wrong, that the effect of this legislation that has been drafted, right, only says that under the procurement law, nobody can challenge the validity of the contract under the procurement law.
That's correct.
Can somebody challenge the validity of the contract under any other law?
Yes.
Thank you.
Thank you, Senator Spaldon. Senator Blas?
Thank you, Mr. Chair. I think, Mr. Chair, sitting back here and listening to all the discussions and everything, and I don't know whether there's still some confusion, at least, and I'd like to clarify it in my mind, and as a result, it will be as a result of some of the questions that I have here. I don't know whether the two gentlemen that are there will be able to answer it, and I'm hoping that there is still somebody that's here that could, if possible. But what was the criteria used to qualify or rate the offers? Can anybody explain that to me?
I passed out the evaluation criteria.
Okay.
Senator, I passed that out earlier. Okay.
Yes.
Okay, I got it. Okay, without going through all of this thing, let me just ask, was the ability to gain financing on their own independently part of the criteria?
Yes, I believe that the offerors needed to acquire financing for this project. It's implicit, however, in the project that they're going to need to cooperate with the government to do so. That was actually one of the protests, was basically the question was asked, well, why is GITA involved in this financing? And the answer was, GITA's legally obligated, that's their job, whenever the government is receiving financing or, and I don't have the language in front of me, facilitating the financing of government projects, they are to work on that. That's their responsibility. The public auditor found that it was within the, and correctly so, that it was within the realm of GITA's responsibilities to work with any of these offerers as they went forward to get financing. That was GITA's responsibility, and they did that. So the question raised in the initial protest, one of them was resolved by the public auditor, understanding Gita's role in this financing by the offeror.
Okay, and if I can recall, and as far as historically and where it was based on news reports and otherwise, I remember there was this there were a series of stories as to, and questioning why Gita and IBC were working already to try to secure that financing. Can you, is there any explanation? What was?
Senator, in all my years, I've never quite been able to explain why the media says practically anything they choose to.
Mm-hmm.
The First Amendment allows them to opine on all kinds of things. But I can tell you what the government did or didn't do and why they did it. I can't tell you why the media did or didn't do.
Okay, so what did the government do?
The government did exactly what it says in the opinions written by the public auditor. Gita, who has the legal authority and responsibility to facilitate the funding of projects for the government, including this one, stood next to the number one offerer when the number one offerer went to acquire funding for this project, as they are required to do. The media saw that however they saw it, Senator. I kind of remember the news reports, but again, I can't be responsible for how the media might have characterized something.
No, I appreciate.
But I can assure you that the Gita did what they were expected to do and obligated to do and authorized to do within this request for proposal. They played their role as they were supposed to play it. If people thought that Gita wasn't going to be involved, they were misinformed or they misapprehended the process that was designed.
Okay.
That the legislature authorized and put into motion. The legislature put the process into motion. DPW, Gita, and DOE did just exactly, I think, what you asked them to do as best they could. That's my assessment of it. I'm not trying to pat them on the back. I've looked at what they did, and I've assessed it from a procurement point of view. And
was there a protest or appeal or lawsuit that was filed by any of the other offerers because of that action?
Both protests raised the concern that IBC was not getting the financing that the government was getting it. Both offerers, both protests were both denied by DPW, and then the denial was upheld by the public auditor, who found, I believe correctly, that IBC was acquiring the financing, not the government.
So it has been already legally asked and answered, Court.
That's correct. Now, I want to clarify one thing, if I may, because I want to make sure the legislature understands what the Superior Court of Guam did and didn't do. The Superior Court of Guam made two decisions. First of all, they upheld the hearing officer's decision that these records are confidential and proprietary and cannot be shared with the offerer who's making a protest, or with you or with anyone else. And they dismissed the case that was filed by the offerer because they sought a remedy they didn't have a right to. The Superior Court did not, quote unquote, vet this procurement. They weren't asked what the offerer requested was a writ of mandamus. They weren't allowed to ask for that, so they the case was dismissed.
Okay.
They didn't pick the right way to go forward, or they chose to get something that they apparently were not entitled to.
Okay. Thank you, Mr. Chair.
Thank you, Senator Blas. Are there any other speakers?
Mr. Chair, I just wanted to clarify something that the bond counsel mentioned earlier with regards to that section on page 3, and that, I looked at you as you explained that and how a little bit weary you were by the language, and that this is not, in your own words, something that you would write in this way. It could be actually tweaked or something to assure that its intentions are specifically directed in that area. And I know the speaker had asked you for a written testimony on something. Were you able to provide that?
Not overnight, no.
Not overnight. How about on something like this within the day? I mean, the language that you mentioned that you would have written it a little bit different. Could we get your suggestions? I'm pretty sure we're going to go for lunch, and maybe we can get that before we go into session. I'm curious to see what you would have written that was different that you mentioned.
No, this is what I wrote, so this is the way I would put it.
Oh, okay.
I'm saying it could be written differently, but without direction, I'm not sure I would know which way to go with respect to drafting it differently.
Okay, then, okay, thank you.
Thank you, Senator Blas. Last, Senator Spaldon.
Thank you, Mr. Chair. Mr. Dirks, you weren't here. I asked a question to the Attorney General, but again, you were here, present at least within this building, to hear what Mr. Brown, Attorney Brown, had suggested yesterday, and that was that perhaps there's other ways to achieve the same objective that we're seeking here. And in essence, it was to allow the protest period of 2 weeks to go forward by, in essence, allowing the disclosure of the proposal from the offerer by perhaps putting that into law or making that more of the gist, so that if that 2 weeks does transpire and there are no protests, then you can then basically issue your unqualified statement or opinion to the bond market. Can I just get your response on that?
My primary response is that that's a very, very big if. In other words, if the 14 days would pass, because if a protest is, if we reveal everything there is to reveal about the successful bidder's negotiated deal and publish a notice of award under some revision of the statute that provides for that and trigger the 14 days, the way things sit, it seems highly likely to me that there will be a protest filed within that 14 days and that we will be litigating that protest for the next who knows how long. And that litigation could go up to the Supreme Court, the Guam Supreme Court. It could take literally years to resolve. And that's the primary problem with proceeding in that matter. The Attorney General rightly pointed out that one of the other problems is that at that point, without having a signed, sealed, and delivered deal with bidder number one, you've revealed all of what bidder number one has negotiated with you, and you're at a great disadvantage when, if and when you then need to start negotiating with bidder number two. So it has that problem as well.
Okay, and the difficulty here, again, and I just want to reiterate, is the way, perhaps the methodology in which we're going for the financing, which presents a problem. And I think perhaps one of my colleagues has suggested that because this is an RFP as opposed to a bid, as well as perhaps the mandate that it should be or shall be a triple tax exempt type of financing. Is that one of the reasons? Are those some of the reasons why we're having difficulty getting past this issue?
The primary difficulty here in comparison to other methods of financing is that it wraps the financing into the procurement with the with the rest of the procurement.
Do we normally do that?
No.
Or have we normally done that when other bond financing?
The only other time we've done it is with the for elementary school financing that we did, and we were lucky. We got through without a procurement protest and without a threat of a procurement protest, and we're able to complete that deal. Um, I'm wondering, after this experience, whether we would ever be able to do that again.
Thank you. Thank you, Mr. Chair.
Thank you, Senator Espaldon. There being no other questions, I'm going to go ahead and dismiss the two gentlemen here. It's second round? Senator Palacios.
Yeah, thank you, Mr. Chairman. Mr. Chairman, I just want to perhaps pose a question or a comment to the Attorney General. With respect to if the passage of this bill as it is would be available, of course, to all the three offerers, and it will not give an advantage to anyone. But I see the current issue as actually a barrier to only one offerer. And this bill then proposes to remove that barrier with the help of this body, so that then offerer number one can proceed. Now, I would say then that even though it would be available, the same mechanism would be available by all three offerers, but the fact that the two offerers do not need this mechanism and they already have a financing arrangement of their own, then I would say that they would be placed at a disadvantage by the removal of this barrier, enabling then offerer number one to proceed. So while it does not necessarily, and I still tend to disagree, but maybe I should say the language in a different way, in a negative way, that it will disadvantage the other two offerers. Is that not an accurate conclusion or inference?
With all respect, Senator, offerer number 2 has exactly the same kind of financing, and offerer number 3 would need, as bond counsel testified earlier, would need the same unqualified opinion, and they all now face the same problem. They all now face the same problem that now the bond counsel needs to be able to warn the bond market that a protest will result in the exact same problem. So I have to say to you, Senator, in my opinion, all three offerers are now in the same situation. It really doesn't matter, and I would defer to Mr. Dirks if I'm misstating it.
No, just one comment and then I'll conclude. It is my understanding that one of the offerer, at least one of the offerer, does not need now a bond financing. And so would not need.
We respectfully disagree with that.
Okay, that's fine. Thank you, Mr. Chairman.
Thank you.
Thank you, Senator Palacios. Senator Taidwi.
Thank you, Mr. Chair. Just a real quick question. You know, since we're worried about this dispute or this protest that might come up, can we amend the law to separate the financing from the construction?
In the future, you can write laws that do that, but you can't amend this law to do that. No, ma'am.
If we can amend the law taking out procurement, there's no way we can separate the financing, so it can't be done. Then what you're saying to me right now is that it cannot be done, that it's just a thought that we can separate the two so that the financing has no
I'm trying to answer your question,
Okay.
Senator. We are not taking this out of the procurement law with this amendment.
But there are, I agree with what he is saying, but there is a second reason why we can't separate the two in this instance. And it has to do with the annual appropriation provision that keeps this from being counted towards the debt limit. Given that the investor's repayment is dependent upon annual appropriations by the legislature, it's important that the facility be built, because the use and occupancy of the facility is the incentive for the government to continue those annual appropriations. So it would not be helpful here to say, the lease is a valid and binding obligation not subject to challenge under the procurement statutes. But nevertheless, of course, it has the subject to annual appropriation language in it. and then, but allow procurement protests about the building of the facility, because the investors would be very reluctant to buy annual appropriation obligations under circumstances in which they were not certain that the facility would be there.
But if this whole problem is being able to float a bond out there, and it's all about the financing, because it's obvious that through this panel, they've chosen the best bidder for this that can, provide the services or build the facilities is not in question. What is in question here is the financing. And if we can separate those two, because the ability for the government to pay will always be there. We might not be a big top rating, but it's been in the future that we've been able to float bonds. So, that being said, I still, there's a big maybe. Like everything that you said here is if and maybe, could happen, could not happen. But we don't have like this will for sure happen other than, another big maybe. So that was just a consideration and just wondering how it worked. Thank you so much.
Thank you very much, Senator. There being no other speakers, I'm going to go ahead and dismiss the Attorney General and Mr. Stan Dirks. Thank you very much, gentlemen. I need to know what's the pleasure of the body at this point. We can break for lunch, come back at 2 o'clock. We're gonna, and when we come back after lunch to then continue our discussions as a committee, and if there's any amendments to be made, to proffer them at that time, and then we just take the process through. I believe, though, that, okay. 4 o'clock? Okay. All right, so with that, we're going to go ahead and break, go into recess for lunch, and we'll be back here at 2 o'clock. Please, everybody, be back at 2. Sir?
Mr. Chairman, is there any way we can have maybe 10 minutes with the, when we come back from lunch with the DPW director?
Right now?
No, not right now, when we come back. And the reason is that, the early indication that it says that the director may go to number 2 as opposed to shall. Now, this is the discretion. I want to find out why he has not gone to number 2. Why he has not proceeded.
I think the attorney, and I'm not arguing.
No, I want to hear from you, because they are the evaluator. He's the chairman.
But I think the Attorney General answered that there is no valid reason to terminate negotiations now.
That's what he said. I want to hear it from the director. The director is the chairman of the evaluation committee.
Well, since he's here already, why don't we go ahead and take that?
We'll go ahead, and if you don't mind.
Sergeant at Arms, please ask the DPW director to come in. Andy? All right, so Senator Palacios, please go ahead and state your question to the director.
Yes, sir. First, let me just make a brief remark with respect to the OPA message to the director. I guess part of the conclusion of the OPA, part of the requirements following, of course, the conclusion of the appeal and those things, is that the OPA requires from DPW the actual cost based upon the sale of certificates of participation. Now, the OPA requires that DPW review the matter once the certificates are sold. That's the OPA's requirement. No certificates have yet been sold, so no one knows what the price is. Now, until the certificates of participation are sold, DPW cannot determine what the ultimate cost of the project would be. And then in its letter to I guess, to the OPA is that on December 4th, is that everything is okay, is proceed. Has DPW determined the cost at some point? in order for it to conclude that it's ready to go and to award? Because we don't know what's the cost.
That is correct, Senator. Before going to the bond market for the company or the proposer to sell or to get certificates of participation, we need to have a number for them in order for them to go to that market and apply for the financing. Once that's been determined, that dollar amount for debt service, then it goes back to DPW. DPW will evaluate it and make sure that it's fair and reasonable before it actually awards the contract.
Has that been done?
It has not, Senator.
Why has not been done?
Because bond counsel hasn't gone to the market. IBC hasn't done the same thing. Bond counsel needs to give his unqualified opinion in order for proposer to go to the market and sell the certificates of participation.
So I ask you, so the inability of this one offerer, the inability to secure bond financing, is that not enough reason to pass that individual because of its inability? Without the aid of this government, without the aid of this legislature, that person is stuck with that inability effectively. Is that not enough reason to go to pass that and then go on to number 2 because you have that discretion? You may stop negotiation with number 1 and proceed to number 2, and then ask you, why haven't you done that?
I think the same question was asked earlier, but in a different way. Senator, all the 3 proposers are going to be required to go and get financing. Because of the protests that occurred prior to the selling of the certificate of participations, because of litigation looming overhead, I think all 3 proposers would have or face the same problems that the proposer, the first ranked proposer will have. In other words, if we went, first of all, let me take a step back. The existing proposer that we are negotiating with right now has met all the criteria within the RFP. We're not saying that the proposer cannot go and find the financing. We're saying that there's a stumbling block, a hurdle that doesn't allow them to do this. And that same hurdle, that same stumbling block will probably be faced by the other 2 proposers when they go to the market. So I think, I know the major reason why we haven't gone to proposer number 2 is because we feel at this point in time that we can go ahead and complete the RFP with proposer number 1.
Yeah, but you don't know that if proposal number 1 is passed on, you don't know that proposal number 2 will be able to secure financing mechanism without the bond, because the RFP says not just tax exempt bond, but also all other financing. And it is my understanding that at least 1 at this point has the ability to self-finance and not rely on the bond financing, but you haven't gone to step number 2, so you would not know. So it appears to me that you're stuck and determined to stay with number 1 and just come to this body and involve this entire government of Guam to come to the aid of this one offerer.
You know, Senator, it's not that it's coming to the aid of one offerer.
It is, because you're not considering number 2 and number 3 yet.
If this bill isn't passed in any form or fashion, we are looking at probably going to proposer number 2. Proposer number 2 will probably, in my opinion, face the same hurdles that proposer number 1 is facing today. But that is, Senator, is my opinion. But I think I think it's my responsibility to see this through, since we are so close to getting JFK built. But Senator, that is my reason for not going to number 2 at this point in time.
If I were you, if I were you, I would pass number 1 and go to number 2. Thank you, Mr. Chairman.
Thank you, Senator. All right. No further questions. I'm going to go ahead and dismiss the DPW director. At this point, we're going to go ahead and take a break until 2 o'clock for lunch. Please, everybody come back at 2 p.m. Thank you. Tina Rose Muna Barnes, Senator Guthertz, Senator Palacios, Speaker Wampat, Senator Anthony Atta, and Senator James Espaldon. Where we left off was we dismissed the panel in order for the committee to be able to deliberate amongst ourselves as to any possible amendments that we may have on the bill or any just general discussions. I have also distributed to all the members. I've also distributed to all the members an opinion paper that was written by Attorney John Brown, and I went ahead and I authorized the page to distribute that to all the members for your information. At this time, does anyone have any remarks that they would like to make on the bill? Remarks, amendments?
I do have an amendment.
We can go right straight into the amendments, or we can have the general discussions at this point. Okay, we'll go right straight into the amendments.
Mr. Chair, if I may.
Yes, Senator.
As I just walked in a minute or two ago, I found a letter on our desk from the attorney who spoke yesterday, from Attorney Brown.
Yes.
I would like to at least have 1 or 2 minutes for everybody to make sure we read it. I'm still reading it.
Sure.
Because there are consequences of law, which he talks about, and I believe it's very important that before we enter into any amendments, that we at least acknowledge or at least look at.
Senator, that's fair enough, and we'll take a 2-minute recess.
Thank you.
All right, this committee of the whole is called back to order. Everybody should have on their desk a total of 7 amendments that have been passed out. Since they were all passed out at about the same time, we're going to take it section by section. So the amendment that has section 1 is hereby amended to read as follows. That would be amendment number 1, and that would be the first amendment that we'll be introducing and discussing. It reads, section 1 is hereby amended to read. And the senator proposing it was J.G., Judy Gutherts. Correct? The second amendment, and mark it as number 2, will be an amendment again by Senator Gutherts, which amends subsection B of section 2. B as in boy. Amendment number 3 will be again an amendment proffered by Senator Gutherts, and that is to add a subsection 2D as in Delta. Amendment number 3 will be the one that reads, that adds subsection 2 Delta. Amendment number 4 will be well, then we'll make the one by Adolfo Palacios, which seeks to amend or add subsection D. We'll make that amendment number 3. And you say amendment, the one by Senator Gutherts is the same? Okay, why don't we, can we do this? We'll make the amendment proffered by Senator Palacios be the main motion, and then we'll see how we can incorporate to amend his amendment to incorporate yours. Would that be acceptable to you, Senator? Okay, so I'm just going to mark yours as 3A, and we'll get, and at the appropriate time you can rise to amend amendment number 3. Amendment number 4 will be an amendment by Speaker Juan Pat, and that's to add a new section 3. Okay, everybody there with me? Okay, and amendment number 5 will be an amendment proffered by Senator Tina Muñoz Barnes to add a new section 4. Okay, everybody's squared away? That's all the amendments that I have so far. Well, I miscounted. Okay, so we should have a total of 5 amendments. So we'll start with the first amendment. Well, I'm going to call on Senator Gutherts to discuss her amendment.
Good afternoon, Mr. Speaker and colleagues. At this time, I would like to offer an amendment to Bill number 1, 5-S. And the amendment is to amend Section 1 of Bill number 1 as follows. Section 1 shall maintain the following language. The Guam Legislature finds that in order to purchase the tax-exempt obligations or other financial instruments to be sold to finance the education facility, a replacement high school to be located on the existing site of the John F. Kennedy High School in Tumon, pursuant to Chapter 58A of Title V, Guam Code Annotated. Investors require certainty that the lease, leaseback, contract, and other agreements relating to the design, construction, maintenance, and financing of the educational facility will be valid and binding obligations when executed and delivered. The Guam Legislature hereby finds and determines that providing such certainty is in the best interest of the territory in expeditiously providing safe and modern facilities for the education of its high school population. That would be Section 1, Mr. Speaker, under legislative findings and intent, and anything after that in the original bill is deleted. I move for consideration of this amendment.
Okay, discussion? Senator Tenorio?
Thank you. I'd like to ask the gentlelady from Manila to yield to a question, which is, what is the purpose of deleting the last sentence?
Sorry. I think the purpose is quite significant, and I think it basically expresses the sentiment of myself, and I hope others in this hall, that we really should not be playing around with procurement law. Thank you very much.
Thank you.
Yes. Mr. Chairman, I thank you, thank the lady for the response. We are, in effect, changing the original legislation by this act. I believe what happens here, based on the information I've received from the guidance of the bond counsel and the others who were here, and by the way, before I proceed any further, I think it would be unwise for us to decide these things without the guidance of the bond counsel in this chamber, which I've been told is not going to be permitted during the committee of the whole from this point on, that we're going to make these decisions outside of the advice of the bond counsel and the others that are here to provide us guidance. But with that, I think this is a way to remove the retroactivity of this. In effect, we're changing the original legislation with this bill. That was the purpose. The purpose is to not go through the entire process again so that we can effectively build John F. Kennedy High School, which I think we all want to do, is build a school for our students and that community to return to John F. Kennedy campus. This is an express retroactivity clause which has to be stated by the legislature in order to effectively make this system work. This is a very crafty way of making it not work, because removing the retroactivity will mean that this has no effect in law. So the legislature has to say, by virtue of Section 702 of Title I, that it is retroactive. When we remove this, then it is no longer retroactive and does not apply to the original enactment of this law, and effectively kills the ability for the government to proceed with the remaining sections, because if we don't say that it's retroactive by legislative intent, and it's not expressly stated by this body, then it does not have retroactive application. So I object to the amendment, and I think that if we want to start the process all over, then we should pass this amendment. But I disagree. We're starting the entire process over because the John F. Kennedy community, the students, the staff, the administration, the teachers, have all tried to make this clear that we want this to happen. There is a small window of opportunity, and this is that window for us to be able to go and to give the benefits which are contained within this bill to not just the first rank, but the second rank and the third rank bidders who provided this government with their bids. So if we remove this section, it does not make it retroactive. And I'm the first guy to say, this is a special circumstance, clearly. But we've talked about the merits of the bill, we talked about the problems with the bill as they were perceived. But if you don't make this happen, we don't expressly say that it's a retroactive, in essence, I believe you're killing the bill. Thank you, Mr. Chairman.
Thank you, Senator Tenorio. Speaker Wampat.
Thank you very much, Mr. Chairman. Mr. Chairman, if you look at line 3, where it says Section 1, legislative findings and intent. And this particular section in itself carries no weight at the legislative findings and intent. And surely this is not the findings of this body, but the findings that was presented to us from the administration. So therefore, this deletion is appropriate because it is only an intent.
Are you done, Speaker Wampat? Anyone else? Wait. Senator Barnes?
Mr. Chair, I just, after reading this section very carefully and realizing that it is just a legislative finding and intent, and probably would bring us to the premise where we're at today, I don't think that it would be harmful for that deletion because it's already been done and worked. We've already gone through that process, and deleting this, it was probably it was just repeating what was earlier said, and deleting this would hold no weight into changing the whole procurement law or the process. So I tend to agree with Speaker Wampat, and I support the amendment.
All right, thank you, Senator Barnes. Any other speaker?
But if I can take a 1 minute break. I know legal. I see one of the legal counsels here, and if I can just clarify that, because I feel like that. I just want to get a perception based on what legal counsel has to say.
Okay.
Our legal counsel.
All right. Well, can you go ahead and discuss with him while Senator Tenorio is, go ahead, Senator.
Thank you, Mr. Chairman. Mr. Chairman, I think it would be prudent for us, and I'm going to make this motion now, that we bring in the bond counsel Stan Dirks, who has stayed on island and not left island, so that he can provide his expertise and give us his assessment of each of these amendments as they become available, assuming that he has input to provide, which would be guidance to us. He is sitting in the hall immediately next to us. It would take next 30 seconds for him to walk in here. So I move that Mr. Stan Dirks, bond counsel, be asked to come in here and give his opinion with regards to this section.
There's a motion. Senator Palacios.
Mr. Chairman, I heard enough from the bond counsel. If that would be the case, then I would like to invite Attorney Brown. I'd like to hear what he has to say about the validity of these amendments. Then that will give us a balanced perspective. So I object to the motion.
There's been a motion to ask.
I object to the motion.
Okay, there's an objection to the motion. All those in favor of the motion to bring in bond counsel, raise your hand. Motion fails.
So, Mr. Chairman, then you're saying that this body is essentially saying that it does not want to seek the legal advice, which is immediately next to us, on matters which may have impact legally on the effectiveness of this legislation if it is in fact passed by the members that are in this hall. We are saying now then that the reason that we left yesterday and came back today, and that Mr. Dirks, who flew out to Guam to provide his expertise, should not be given to this body at this time because we've already heard him? Well, we haven't heard him on these things that are in front of us. And that the reason that we are in the committee of the whole is to have the liberal interpretation, the ability to banter and speak and have conversations between ourselves, to be able to talk about the amendments before us, and to not have someone who's got as many years and expertise in the legal community dealing with bonds to come into this hall and give us advice, I think is asinine. What are we doing? Are we going to proceed down this course based on our expertise and our understanding and interpretation of what was discussed up to this point? Why are we not bringing someone who is immediately available to, Mr. Chair, I'm not finished yet.
No, but Senator, you raised the objection. I called for the vote from the body, and the body took a vote that they preferred not to have legal counsel in here. And that's what we spent the whole day yesterday, so that we can basically ask the questions and get ourselves as informed as possible, so that when we deliberate today, we would be able to then come to our conclusions
So, Mr.
based
Chairman-
on the information we have
Mr.
received.
Chairman, that's like saying
But-
you
but
went to the
Senator-
lawyer one day and you spoke to the lawyer and then you said you're never going to go back to that lawyer because you already spoke to him once.
Senator, you made a motion, and I asked the body for a vote, and your motion did not carry.
So are we the committee of the whole?
We are in the committee of the whole, and a motion was made, it did not carry, so the motion is dead.
And so we cannot
And
speak
so
on
the motion is dead, that the body does not care to have bond counsel sit in here. The body has expressed its desire to then deliberate amongst ourselves based on the information we have received over the past day and a half to make the necessary amendments and to move forward with this bill.
So, Mr. Chairman, is part of the deliberation the opinions of members of this body?
Senator, you made a motion to bring in counsel. I asked for a vote from the body here, and your motion did not carry. The motion is dead. Okay? Now, you can interpret it any which way you want, but the bottom line is your motion did not carry. Senator Spaldon.
Thank you, Mr. Chairman. If my understanding is correctly, the previous motion was to ask bond counsel to sit in, and so because of these amendments, one of the objections that was raised was basically by a colleague who said he would also, if we're going to bring in bond counsel, that he would like to also bring in Attorney Brown as well. And so I then make the motion to bring in both bond counsel and Attorney Brown into this session floor so we can consider perhaps the legal ramifications of these amendments. Even though we discussed with them the legal arguments on the proposed bill as it was, it has no effect in terms of the legal perspective they may offer on the amendments and what it would do to the legislation as we either vote for or against the amendments on it. So if the basis for objecting was that we were not going to allow Attorney Brown in also, then I would like to move that we bring in Attorney Brown and the bond counsel. That's a separate motion. It's a different motion for the first.
There was a motion to bring in both bond counsel and Attorney Brown. Speaker Wampat.
On the motion.
On the motion.
Thank you very much, Mr. Chairman. Mr. Chairman, all day yesterday, we have methodically brought in one person at a time to establish and set the process of the procurement process, and we were able to ask questions so that we can get facts. That's what we wanted to do, was to get facts. And we brought in individuals even with different opinions, and then after gathering all that, you know that the next step then, basically, that all the facts that was available to the senators, that now then, that we deliberate on our own. We're in a committee of the whole, yes, to bring in individuals, to provide some information. We've done that. That was our fiduciary responsibility, to do just that. And I would think that members of this body then, who have already heard the arguments from all sides, that we are now capable of deciding on our own, in the best interest, yes, of the people of Guam. And I really hope that we're not using this time right now to pander to anything. And I need not remind our members that we're here at a critical moment to make some decisions, not for ourselves, but for the people of Guam.
Thank you, Speaker. Senator Palacios.
Thank you, Mr. Chairman. Mr. Chairman, we sat all day yesterday and again this morning. We listened to both sides of the aisle of the arguments. We read materials. I tell you, Mr. Chairman, if I am not ready to deliberate today any more than after what we heard, then I tell you I will never be ready to deliberate. But I am ready to deliberate personally because I got all the facts. I am ready. And whoever's not ready, then he will never be ready. So I object to any more this legalistic presentation that's just going to further confuse us. And I object to the motion. Thank you, Mr. Speaker, Mr. Chairman.
Thank you, Senator Palacios. Senator Blas.
Thank you, Mr. Chair. Mr. Chair, on the motion. You know, this body has utilized the Committee of the Whole on many occasions, other than this occasion, to be able to not only to be able to hear from the subject matter experts when we're deliberating matters that are before us, but this body also has had many opportunities when they were there, and it was good then, I don't know why it's good now, that we would bring amendments to the floor while the subject matters were here so that we can be able to get their guidance and get their opinions on the issues that are before us. Yes, I agree that we spent many a time the last couple days in being able to talk to bond counsel and other consuls and other subject matter experts on what is contained in the bill. Now what we have before us are amendments that will change that. And I think that it will only be prudent for us as a body to be able to ask these subject matter experts, because we are not the subject matter experts, on what their opinion is and what they believe would be the ramifications of what this body is going to decide. And with that, I ask my colleagues to please, despite the objection, to please support the motion to bring both consuls in. It's only fair. Thank you.
Thank you, Senator Blas. Senator Espadon, do you want to close on your motion?
I would have to tend to agree with the previous speaker, Mr. Chair, only in that now I think some of the when we first went down this road of trying to get JFK built, we actually, in good faith, with good intentions, went down and created the legislation that enabled it to. However, we have gone down this path just to find out that because we did not perhaps dot our I's and cross our T's in addressing some of the legal issues, that we have found ourselves now in this predicament that, again, it has stalled the process. And I just want to make sure that since we are here to resolve the going forward, that we do have at least guidance of people who are already here. Again, and it's not to question them anymore about what's gone on in the past, but going forward, whether we are actually creating more of a problem than we are really trying to solve. And I think that's the real essence of my request, to make sure that if we are creating a problem, that we should know right now, as opposed to creating this thing, coming back 3 months, 2 months, 1 month down the road, just to find out that we have actually dug a bigger hole than we really intended to do. And that's really just the essence of the motion to bring in these councils. Thank you, Mr. Chair.
Thank you, Senator Spaldon. I'll call for the vote now. All those in favor of the motion to bring in both bond counsel and Senator Brown, all those in favor, please raise your hand. Motion fails. Okay. Any further discussion on amendment number 1?
Mr. Chair, again, excuse my ignorance, but since we are still in the committee of the whole,
that's right,
and we are allowed to bring in, and people are free to come in, is it permissible to ask bond counsel perhaps to sit beside me, since he won't be addressing the whole body, but for me to be able at least to seek his guidance as we go down? Is that allowable under the rules? And if it is, I'm requesting that he does. Can we have this discussion on, I mean, just to make sure. I just want to make sure. I'm asking because I don't know personally.
Council, we're going to take a 1-minute recess. This committee of the whole will now come back to order. In response to the question about allowing legal counsel to take a seat next to a senator to provide advice, there's nothing in the standing rules that addresses that issue. As the chair, will rule that I will not allow anyone in the session floor during this proceeding here. So, with that, Senator...
So, Mr. Chairman, I move that we rise from the committee of the whole because we're not bringing anybody else in. Why are we taking several bites of the apple? We don't want to hear what we don't want to hear. Let's rise from the committee of the whole and move on these amendments without the benefit of anyone else.
There's no objection?
A motion will have to be made that if we're going to rise as the committee of the whole, what are we rising for? Do we have a bill that we're going to recommend to do pass or what? Please clarify the amendment, your motion.
Mr. Chairman, I then rise from the committee of the whole on the matter of Bill 15-S as introduced by the Committee on Rules, Natural Resources, and Federal, Foreign, and Micronesian Affairs by the request of a Magalahin Guahan in accordance with the Organic Act of Guam and to resume in the second reading, at which point we will resume discussion on Bill 1-5S and make amendments as necessary during that period.
Are there any objections? There being no objections, without objection then, so moved. We will now take a brief recess to return to the regular session.
The legislature is back. It's called back to order. Senator Ada on the as chairperson, acting chairperson of the committee of the whole.
Madam Speaker, having completed deliberations, the Committee of the Whole wishes to report back its findings and that there being and the recommendations to place Bill 15-S back to second reading to resume discussions.
And the motion then actually is that we've risen without any recommendations, without any amendments. So.
That's correct, Madam Speaker.
Okay, so on that motion then, without any objections, we're in second reading. That's the motion.
So, Madam Speaker, as a point of information, we originally made a motion to place the bill in third reading.
No, we did not.
Just a second. Just to resolve to committee of the whole. At that point, we gavelled, We went to the committee of the whole. Now we have risen, and my motion was, as you had indicated, that we will resume discussion on the bill. So the original motion to place the bill in third reading is still standing. We have risen from the committee of the whole. We are still on the bill, and we're still acting as though we normally do in every bill except for the committee of the whole. So we've risen from the committee of the whole. They are now discussing. Everybody has one opportunity to speak and, of course, to make amendments and to talk on those amendments as we normally have. So nothing further will happen except that and as I understand it, that the members of the body will now discuss in the normal fashion the bills and the amendments that they have.
Senator Tenorio, I am aware of the motion that you made, and we all know exactly the procedures when we're going to go into the committee of the whole. The amendment that I'm entertaining here right now is strictly that this is being recommended, we're rising, without any recommendations at all. So there are no amendments intact, as is, to the second reading, where then further discussions may take place. Yes, and that's exactly what I was going to call for before you decided to reiterate exactly what was said. Without any objections, so ordered. Senator Guthrie, you're recognized.
Madam Speaker, I have an amendment to Bill number 1.
Yes, Senator Guthrie, you may proceed with your amendment.
Thank you.
I would just like to remind our colleagues that the original numbers in which the chairman had actually identified, that I will be calling those amendments in those same order.
Thank you, Madam Speaker and colleagues. My amendment is to amend Section 1, the legislative findings and intent of the bill, to read as follows. The Guam Legislature finds that in order to purchase the tax-exempt obligations or other financial instruments to be sold to finance the education facility, a replacement high school to be located on the existing site of John F. Kennedy High School in Tumon, pursuant to Chapter 5(8-A) of Title V, Guam Code Annotated, investors require certainty that the leaseback, contract, and other agreements relating to the design, construction, maintenance, and financing of the educational facility will be valid and binding obligations when executed and delivered. The Guam Legislature hereby finds and determines that providing such certainty is in the best interest of the territory in expeditiously providing safe and modern facilities for the education of its high school population. And that would be the language, Madam Speaker, of Section 1, legislative findings and intent with this amendment. Thank you.
Senator Tenorio, you're recognized on the amendment.
Thank you, Madam Speaker. Madam Speaker, I object to the amendment on the basis which was given during the committee of the whole. Thank you.
Are there any other speakers on the amendment? Senator Palacios, you're recognized.
Madam Speaker, I rise in support of this amendment. Any time that you have a provision, Madam Speaker, that has to do with retroactive, it casts doubt in my mind as to what really is the purpose and the issue. And the RFP is started, evaluation has started. Let us continue forward and not look back. Thank you, Madam Speaker.
Thank you very much, Senator Palacios. Senator Muñoz-Barnes, you're recognized on the motion.
Si Zeus Masi, Madam Speaker. Madam Speaker, I share the same sentiments with the previous speaker. I do support the amendment as proffered by Senator Judy Gutherts, and I think that looking retroactive and not moving forward on this, I've already said earlier when we were in a committee as a whole that this, for me, brings some doubt to my mind, and we've already gone through certain steps already, and we need to move forward. We need to move forward, and I think that in our legislative findings and intent, it just brings us up to speed on what has happened, what needs to happen, and I just think that this paragraph is not necessary. So I support the Senator Guthrid's amendment. Sisos Masi.
Thank you very much, Senator Barnes. On the motion, are there any other speakers? There being none, Senator Guthers, would you like to close?
Thank you, Madam Speaker. Just a few words on the amendment and why. And again, this is simply the language for Section 1, legislative intent, findings. I think we had the opportunity over the last 2 days to listen to a lot of information and evaluate that information. And as I said earlier in my discussion, this is a very difficult circumstance for all of us here today, because I think all of us here want to see the new school built as quickly as we can. Unfortunately, just in this legislative intent, if we did not amend the original words in the legislative intent, right up front it would make clear that it is the intent of this legislature to prohibit the possibility of any challenge or protest to be filed against the award of the contract. And I really believe that that is not an appropriate thing for this legislature to do. We would just be changing the entire history of Guam procurement law to do this. And I think it sets extremely bad precedent. So up front in the legislative findings, my amendment simply would delete those words in the original legislative intent in the bill that would in fact make it clear that our intent is to bypass the procurement law as it is written today. Thank you.
Thank you very much, Senator Guthers. All those then in favor of the Guthers amendment, please raise your hand. Okay. Failed to get the required votes. I'm sorry, Guthers, it didn't pass. Amendment number 2, I recognize again Senator Guthers.
Thank you, Madam Speaker and colleagues. Amendment 2 would basically amend subsection B of Section 2 of Bill number 1. And the new language of subsection B would simply be the following. Upon the execution and delivery by the education agency of the contract, the leaseback, and any other agreements relating to the design, construction, maintenance, and financing of the educational facility, the contract, leaseback, and such other agreements shall be valid and binding obligations of the education agency, enforceable in accordance with their respective terms, period. Everything else that was in the original Section B of Section 2, subsection B of Section 2, would be deleted. Thank you, Madam Speaker.
On the motion, is there anyone who would like to speak? Senator Espaldon, you're recognized.
Thank you, Madam Speaker. Hang on, Madam Speaker. I'm only 5'4", my microphone is 5'8". Oh, it's meant for tele. Anyway, I'll just, there you go, down this way. If I may just pose a question, and if the author of the amendment would yield to a question, the question would be to ask her what her reason is for this amendment.
Senator Guthers, do you yield to the question?
Similarly to my previous comments, Madam Speaker.
Hey, microphone.
Thank you, Madam Speaker. Similar to my previous comments, I really don't feel it's appropriate to limit anyone's rights with reference to our procurement laws. Thank you.
Well, in that
Senator
situation,
Espadon.
with that, thank you, Madam, thank you, colleague, and thank you, Madam Speaker. It seems to me that, though, that this really exactly does just that, right? In other words, by the legislature declaring that this is a valid contract, we already, in essence, are saying there is no remedy. Whereas in the original language, the only limitation was a remedy under the procurement law. And again, I think this is where earlier when we were in the committee of the whole, it would have been great to be able to ask legal counsel if that is indeed was what would happen by this type of amendment. Are we really achieving the end that the author of this amendment is proffering to accomplish, or is it really the opposite? Are we now taking it upon ourselves that we are now the ones to be able to say there is no more remedy because there is no more challenge, and it's not just restricted to the procurement law, but now perhaps other areas of law, which were spoken to while we were in the committee of the whole, that even though that the original language before this amendment, basically there may not have been a remedy or a limited remedy in the procurement law, there were still remedies out there in contract law and everything else. The question that has become is by going down this road and creating this action, does that then prohibit anybody from seeking any other kind of remedy, or at least in terms of the legality of the contract? That is a question that
Are you asking the author to?
Well, she seems, the good senator seems to be willing to at least address it, so if
So
I will, I'll pose
you would
that
like
as a
for her
question.
then to respond?
Please.
Thank
Senator
you,
Gates.
Madam Speaker, and I thank the good senator for bringing it up. I think a clarification is required, and I'd like to make an amendment to my amendment.
Okay, but.
This may not be the opportune time.
Yeah, well, I'll allow you to do that when you close. I will
Okay,
have
all right.
Senator
But I
Espadon
understand
to
what the good
proceed.
gentleman is saying, and I
Yes.
have a simple amendment that will address that.
Thank you, and then again, I will reserve it until that amendment, my other comments, depending upon what that amendment may be. Thank you, Madam Speaker.
You're welcome. Senator Palacios, you are recognized on the amendment. You want
Madam
to speak?
Speaker, I would like to offer an amendment to the Governance Amendment. And on line 5, after the respective terms, comma, and in accordance with Chapter 5 of Title 5 of the Guam Code annotated, period. We have
So
to include
you're-
that so that continues to apply, because I gather from the last speaker that if you're going to strike all of this out, then what would be binding would be what are the terms of the contract. But it would have to say the enforceable in accordance with the respective terms and in accordance with Chapter 5 of Title 5 of the Guam Code annotated, period.
So your amendment to the amendment will be to add then at the end of terms to
Yes.
say
And in accordance.
and in accordance with Chapter 5 of Title 5
Of the Guam Code annotated. Thank you.
On
That's
the
my
amendment to the amendment, Senator Blas, you're recognized.
Thank you, Madam Speaker. And, Madam Speaker, I just need to be able to caution the body that although, yes, we were talking about Chapter 5, Title 5, we also got to remember that we're talking about a certain provision specific to the construction of JFK, which is a separate and a distinct section of Title 5, Chapter 5. And so I don't know what those ramifications are going to be. And to be able to make an informed decision with regards to this amendment, I'd like to be able to take a little bit of a break before we even jump into the water on this thing, recognizing that there are subject matter experts that are next door, to give an opportunity to be able to check with them before I can even cast a vote on this.
I think two of your colleagues have just done that.
Well, so if anybody's going to speak, then give me the opportunity to run across.
On the amendment, to the amendment, which is Senator Palacios' amendment, which is to add in accordance with Chapter 5 of Title 5 of the Guam Annotated, I recognize Senator Tenorio.
Thank you, Madam Speaker. Madam Speaker, I will have to, as we all will, in seeking advice, consult with Mr. Stan Dirks instead of having him in the committee of the whole. So I took a minute, as you saw, and spoke to him. His opinion is that it would be worse than it already is, and for that reason, I object to the amendment
On the amendment to the amendment, are there any other speakers? Senator Blas, I'm giving you an opportunity to come back and continue where you left off. Sergeant at Arms, can you please call Senator Blas? There's an objection by Senator Tenorio. Senator Blas, do you want to continue? On the amendment to the amendment, Senator Palacios, would you like to close? Or you want to just go ahead and call for the vote? All those in favor of the amendment to the amendment, please raise your hand. Because since there was an objection, okay, the amendment failed. We're back to the original amendment by Senator Guthertz. Are there anybody else who would like to speak? There being none, I'm going to give the floor then to the author of the amendment, Senator Guthertz. Okay. I'm going to call for the vote. All those in favor then of the Guthertz amendment, please raise your hand. Nobody actually, in this case, actually said any, so therefore there being no objection. Okay, so there is the objection now, so those then in favor then, please raise your hand. Yes, in the Guthertz amendment. Motion fails. I'd like to recognize Senator Palacios on an amendment, which is to add a subsection D to Section 2.
Thank you, Madam Speaker. Madam Speaker, the proposed amendment is to add, of course, a subsection D to Section 2. And this amendment is consistent, Madam Speaker, with the fact that very condition that we are here in an emergency session. And so this adds urgency to what is already urgent. And that is that the contractor selected through subsection A of Section 58A105 shall be deemed disqualified if funding is not secured within 30 calendar days from selection. If funding is not secured as required by this section, then the Department of Public Works shall proceed with the next best qualified offerer as provided in Section 3114, parenthesis 1 and parenthesis 4, Chapter 3 of Division 4 of Title 2 of the Guam Register.
Guam Administrative Rules.
Guam Administrative Rules. And that's my amendment, Madam Speaker.
Oh, wait.
Thank you.
Right, this, we're going to have to, we're looking at Section 2, so that will be a C rather, a subsection C rather than D. Senator Taitigui, you are recognized on the amendment.
Thank you, Madam Speaker. Madam Speaker, I definitely understand the urgency of this. JFK has been waiting way too long. And, but the calendar days in which from selection is very, very strict, and it's very difficult to receive any type of funding in any way, even through some mortgages take longer than this when you're just getting a home. So, Madam Speaker, I would like to make an amendment crossing out 30 days to make it at least 90 days.
You want to continue talking, or do you want me to call on the...
Madam Speaker, this is very complex, as I mentioned earlier. And to be able to choose the right individuals, the investors that are coming forth with being able to provide monies for these bonds. In past histories, yes, we might be able to get it sooner. And I'm pretty sure that, you know, Gita and the people involved in Bond Council are going to do their best to try to meet a lot less days than 30 if they could. But to put a timeline of 30 days is just unrealistic for this to happen. So I'd like to make an amendment to at least to put it to 90 days.
On the amendment then to increase the number of days from 30 to 90 days, Senator Calvo, you recognize on that amendment?
Yeah, thank you, Madam Speaker. Madam Speaker, I just had a discussion with Stan Dirks, and again, this is a recommendation by him as well, that the comfort level of 90 days would be satisfactory, dealing with, again, having to deal with the issues of moving forward in financing. There is a belief that 30 days may be inadequate. So again, I rise in support of the amendment.
On the amendment, are there any other speakers? Are there any objections to the amendment? There being none, amendment carries. So therefore, on the main amendment then, is there anyone else who would like to speak on the main amendment? Senator Tenorio, then Blas, then Calvo.
Thank you, Madam Speaker. Madam Speaker, this may be able to work if we change the word selection on line 2 of this amendment from selection, because the selection occurred last year. It's been a long time. And so 30 days from that wouldn't be appropriate. We're not going back in time in the sense that we're talking here about the selection, which was 30 days from that date, and clearly would not be the case. So I'm trying to work out something again with our bond counsel, Stan Dirks, and enactment of this legislation, which is effective this term, when the session we're in at this moment, would be advisable. But I need to consult with my legal counsel to make sure that we're on the same sheet of music, so to speak. So I'm going to make a recommendation to change selection on line 2 to enactment of this act. And then I'm going to listen to the debate, but I'm going to consult with my legal counsel as well as Stan Dirks to make sure that that would be sufficient. But I think we want to make sure what we're doing here is we're giving 90 days from the passage of this act, not the passage or the selection from last year. We're talking about here, now, today, and immediately after this. So 90 days from this act being passed by this body, we give adequate time, not 30 days from last year when the selection was made for the first ranked bidder. So that's my amendment, and I'm interested in the discussion.
Let me understand your amendment, because it's not upon enactment by this body, but upon enactment and when the governor signs the bill into law. Is that what you're trying to say?
That's why I need to consult my legal counsel, but to make sure that we're doing the right thing.
So the words are that it will be 90 calendar days upon enactment.
Well, if you give me a minute, I can actually give you the fine
I'm going to go to the next
language.
speaker, Senator Blas. I'm being very lenient here by allowing all this time back and forth. Right now still on the, yes, on the main motion. Yes.
Thank you, Madam Speaker. And actually, Madam Speaker, my concern was actually with regards to the same language and everything. So you can go ahead and move forward, and I will reserve until...
Senator Calvo, you recognize.
Thank you very much, Madam Speaker. Again, in my discussion with Stan Dirks, that was the issue I was going to discuss, that particular area in regards to from selection. So now that is being, again, handled by the earlier speaker, I have no further comments on particular to the measure.
Senator Guthers, you did have your hand up. You're recognized.
Yeah, Madam Speaker, I sort of have a question, and if anyone can answer this. My understanding is the contract has not yet been awarded. Am I correct?
Yes. I shouldn't be the one answering the question. We should ask
I'm confused about this. How does that jive with the fact that the contract has not been awarded? Someone can answer that?
Would anyone like to attempt to answer that question?
Madam Speaker,
Senator Espadon?
thank you, Madam Speaker. If I recollect, the contract cannot be awarded until actually after they go to the bond market. So that is not really relevant at this point in time in terms of the award of the contract, because the issue here is whether we can go and proceed on. The purpose for this bill is to make sure we can go to the bond market and which this bill would allow the bond counsel to give an unqualified opinion, and that would basically then allow us to go to the bond market. After that is secured, then the contract is awarded. That was my understanding from all the discussion from the past 2 days.
Thank you very much, Senator Espadon. Point of inquiry.
Madam Speaker, if the selection is already made, then who is selected? Who has been selected?
Thank you very much, Senator Palacios. I guess nobody wants to respond to it. Senator Tenorio, we're back to you then. You understand you've got some counsel.
Yes, thank you, Madam Speaker. Colleagues, I'd like to now move the final amendment, which again will be replacing the word selection with enactment of this act that adds this subsection. So we would say, the contractor selected through subsection A of 58A 105 shall be deemed disqualified if funding is not secured within 90 calendar days from enactment of this act that adds this subsection.
On the Tenorio amendment, would anyone like to speak on it? The amendment is to delete the word selection and add the following: from enactment of this act that adds this subsection. Senator Blanche, you're recognized.
Hi, Madam Speaker. I rise in support of that amendment. It actually clarifies and actually speaks to the concern with regards to that word selection. I think there was too much debate, and we can get into too much debate, and it's too far as far as what the term and the definition of what the selection means. This adds the clarity. I think this is truly the intent of this body, and so I'm in support of that amendment.
Senator Tenorio, can you please provide your amendment for the clerks? And once again, I'm going to repeat the amendment to make sure everybody understands it. Delete the word selection, then it will be from enactment of this act that adds this subsection. Does everybody understand that? So please submit your amendment. So on the Tenorio amendment, then to the amendment, are there any objections? No objections, so ordered.
On the main amendment.
On the main amendment, yes, you're recognized, Senator Tenorio.
Madam Speaker, there's technical, but I just want to make sure it's clear that the last line of this amendment, which is 3114, and then in parentheses 1, that should be an L, as I'm told by legal counsel, and I want to make sure that we're not placing the wrong characters in the parentheses that gives the proper section citation. So it would be 3114 L4, as I'm told by legal counsel.
Yes, that is a technical amendment, and the clerks will take note of that. So on that technical amendment, without any objection, so ordered. On the main amendment, who else? Is there anybody else who would like to speak on it? Senator Espadon, you're recognized.
Thank you, Madam Speaker. Madam Speaker, on that line, on the second line, if I may read it again, if funding is not secured as required by this subsection, the Department of Public Works shall proceed with the next best qualified offerer as provided in 3114 L4 of Chapter 3. The operative word here is shall. Now, we have heard that, in the previous day and a half, right, that really that's more of a discretionary call from the Director of the Department of Public Works. And so we're changing now the scope of the game as well, right? Now, it has also been explained that in the packets of all the three offerers for the building of JFK, at least according to the bond counsel as well as the attorney general, that all three of them, according to their bid packet at that point, would have required the assistance of GITA, in essence, the government of Guam, to go before the bond market to be able to secure the financing that was proposed in their packets. We are taking away, I mean, now if they go down this road and we say shall, even if we do mandate that now number one offer is no longer, number one ranked offer is no longer in this game because he has not secured financing because perhaps we have not met the requirements as stated by the bond counsel to give assurance to the bond market, right, that with an unqualified opinion, then by saying shall proceed really brings it back to the same situation for the second offer. Because if indeed it is true that the bond counsel's and the attorney general's remarks are true, that even the next guy and the next guy after him, that all three of the offerers would need to be standing with GITA, or GITA would need to be standing with them to be able to go for the financing that was included in their packets, then this has the effect of only delaying the process even further by mandating that you keep going down that road, right? As opposed to allowing the discretion of the procurement officer, the director of public works, then to make the call saying, well, this is untenable, maybe it's time to go for another offer. So I just want to caution, or maybe I'll go ahead and make the amendment to change the word shall to may.
On the motion then to delete the word shall and to add the word may, Senator Palacios, you recognize, and then Senator Guthertz.
Thank you, Madam Speaker. Madam Speaker, the very reason, one of the reasons why we're here today is because of the seeming inability of the public works to exercise, I guess, expeditious judgment by relying on the may and the shall. And it's about time we get involved. Right now we are involved. Then we have to proceed and go. If he would not go down to the second, then this amendment would then go ahead, abandon the first offer who is not able to secure financing and go on to the second. But because it was pointed out in presentation earlier that because the word did not have, the provision did not have shall, then actually the Director of Public Works can just sit there forever. And we are here because of that, because of the seeming inability to exercise sound and timely judgment and decision on this one. Thank you, Madam Speaker.
Thank you very much, Senator Palacios. On the amendment, Senator Guthertz, you're recognized.
Yes, Madam Speaker. I object to the amendment, and my reason is very simple. In the original solicitation for companies to participate in this project, I understand there were 3 bidders that were considered, and the Department of Public Works ranked them and chose who they thought was the best bidder, best proposal, and has been going through this process for, I don't know, 2 years to bring us where we are now. And I think we are assuming from the previous discussion, the original discussion on this amendment, that there could be a problem with the government, perhaps in getting the bond issuance. But what if it's not the government? What if for some reason the bondholders are not supportive of the entity itself? Not the government entity, but the company that has been identified as the company to possibly build the school. I believe the procurement law is very clear on what the process is supposed to be, and this clarifies it to make it very clear, if it's not clear already, to Public Works. Follow the process. Go through the process. There were 3 bidders. We start with the one they are seem to be comfortable with. Let's see if they get their financing. If they don't, then you go down the line. Thank you.
Senator Senator Guthertz on the motion. Senator Blush, you're recognized.
Thank you, Madam Speaker. Madam Speaker, I rise in support of the proposed amendment here. I rise in support of it for the simple reason that I think over the last couple of days we've heard the discussions with regards to the what ifs and the what ifs. And the concern that I have here in keeping the word shall is it restricts us from being able to exercise other options that we may present us as a result of going through an exercise. If going through the exercise with the first with the first contractor or the first bidder or the first offerer for that matter, and the government starts to see that because of what they had to go through in that exercise, and it is not in the best interest of our people, then we're limiting government's ability to be able to say, okay, this is not going to be in the best interest of our people. We're going to move on to another into Plan B if need be. Keeping this at shall basically says, despite that, you know, and I appreciate the, you know, what the previous speaker had said, but let's change this around. Let's say that the bond buyers have issue with the government, or have issue with regards to some of the things that we're placing on, and are going to make either the interest rate higher, the terms longer, or whatever it is, it won't be in the best interest of our people. We're going to restrict and we're going to limit our ability to be able to say, okay, in order to be able to build JFK, we're going to have to go to another route. Now we're saying, even if that exercise were to occur, and we saw that it's not in the best interest of our people, guess what? We're going to have to go to the next person. And we're going to go through that same exercise again. It's not going to work. So we're limiting by saying shall. And I prefer that the language say may. Thank you very much.
Thank you very much, Senator Blush. Senator Ada on the motion.
Madam Speaker, I rise in opposition to the amendment. I think from the very beginning, when the law was initially enacted, this government chose a course of action to take. We chose to authorize DPW to go out and issue an RFP for the purpose of getting JFK constructed. DPW did just that. They tried to put together as best an RFP as they could within the time limit that they had, and then they went down that, pursued that course of action. I think that now that we are here, we should continue to stay on that course until we bring this to finality, and if we find that the initial plan just does not work, then let's start all over again. But it seems that this notion by changing it to something more permissive, that he may, such that then, for example, let's say the current offerer is not able to obtain financing, then the DPW director has the authority to say, game over, and throw everybody out, and then start all over again without giving the benefit of the doubt to the other two remaining offerers who have already put in a lot of work. Now, we're assuming that the process is just going to be prolonged, because I think, my understanding is that we're using information that is outdated. And of course, when you try to press it, well, we can't discuss it because it's sealed and all that stuff. But it was mentioned during the Committee of the Whole that back in January of 2009, I believe that was the date, that all three offerers came in, and at that time it was true they needed to get financing, and they probably would have had to go to the bond market or USDA, which would have required that unqualified opinion from bond counsel. But if we were able to receive more current data, and if in fact there is, let's assume that one of the three offerers right now took the initiative to go out and find financing and was able to say, I've got the money, I've got the plans, and during the evaluation, DPW said all the construction evaluations were responsive. GIDA indicated that the financing plans were responsive. Now, if offerer number 2 and number 3 were just way out in left field, and that it really will be a futile exercise to continue the discussion, then I can see where there will be basis and grounds to just terminate the game. But I think we've gone down this far, and we've got to press it, and we've got to continue and stay on course. And if that first one does not come back with financing in 90 days, you're out of the game. Number 2 comes up. If he gets into the same situation, you're out of the game. And then if number 3, so we're talking about, I would hope that by now these people would have realized what it's going to take and that they're doing their homework so that it's not necessarily going to be a 90-90-90 before we finally get a decision or a selection of a contractor to start building JFK. But, it's very possible. It's very possible that, in fact, we got a letter here from counsel of one of the offerers. They got the financing in hand, and they can start as soon as DPW, if their turn came up to bat, that they can start as soon as DPW is able to give them a permit to begin work. So I say let's stay the course and let's let this thing play itself out. And when we find that this plan just was not tenable, then let's start all over again. But let's see it to the end. We're almost there. So, Madam Speaker, I would ask my colleagues to reconsider, and let's keep this prescriptive, that here's the course of action that we want to follow, and let's stay on course. Thank you.
Thank you very much, Senator Ada. Senator Tenorio, on the amendment.
Thank you, Madam Speaker. I've listened very closely to my colleagues and the amendment which was offered. I remember yesterday when we had John Weisenberger here, and he talked to us about the permissive nature of the original language. And one of our colleagues said that this is consistent with what the procurement law effectively says, is that we need to proceed down to the next offerer. And I think what I remember is it said you may go down to the next offer. It's not required. And I think the reason, as I understood that, is that some things are not good for the government, should not be pursued. You can't be forced to go down. Let's say my good friend Senator Tony Ada here is part of the government, and he wants to buy plastic cups. And the first offerer says, well, we'll sell them for $1. And the next offerer comes in and said, well, we'll sell the same thing for 10. And the next offer is 25 per cup. So what we're saying here is that, well, if the guy who wants to go get those cups for the government of Guam doesn't get financing, then the government of Guam is forced, excuse the water being spilled, is forced to go buy a $10 plastic cup when you could get a $1 cup. So instead of saying may, we're saying you're forced to go to the next guy and pay 10 times the amount of money for the commodity or the service that you are trying to obtain for the people of Guam, because this law says you shall, not you may. That doesn't make sense to me. Yes, we want to build John F. Kennedy High School, but we don't know what the terms are. These are sealed negotiations. They're not subject to discussion, and we don't know what all the facts are. So I don't know if what we're looking at right now is a $69 billion John F. Kennedy Cup, and the next one is $150 million, and the next one is $250 million. We don't know. I don't know. Am I the only one? But I don't want this government to be forced to go to the next bidder if it's not in the best interest of the people of Guam. And we have professionals, and we've seen the list of those members who are part of that process of evaluating and ranking the most appropriate provider or bidder. I'm not going to go pay $10 for a plastic cup when I can get it for $1. I think the language offered by my good friend from Tamuning is prudent and is consistent with the procurement law, and I ask that we change it to may. Zusmase.
Thank you, Senator Tenorio. Senator Taitagui, please state your point of inquiry.
Maybe someone can clarify this for me, Madam Speaker. I thought that what happens is, based on the Director of Public Works explanation, he said that they have been in negotiations with the first bidder. Am I correct?
Yes.
All right. Now, I would assume if for some reason things don't work out with the first bidder, and they follow this process, the shall process, that then they go to the next bidder and they start discussions and negotiations with the next bidder. It doesn't require them to select the next bidder. It requires them to consider the next bidder and to negotiate with the next bidder. And if that one doesn't work out, then they go to the third bidder and they do the same thing. And then if none of them work out, then they start over. That's my understanding of the discussion over the last 2 days.
Senator
Thank
Guthrie.
you.
Senator Pt.2.
Madam Speaker, listening to the debate on this and tossing it back and forth, I think the good senator from Manila made a lot of sense, more so than anything. But I did have a chance to speak to somebody. The word shall. Whether the first bidder goes up to seek bonding, to seek the finances needed, what makes us for sure know that the second bidder is going to be able to get the bonding too, if the first one couldn't even get bonding? So in that perspective, you have to think of that. But Madam Speaker, it's the process that we're going through. If they don't get financing from the first bidder, and DPW decides, well, let's start all over again. You know how much work that's going to take and how much time the kids from JFK is going to have to wait even longer? So considering the time levels and considering the fact that if number one can't get bond financing, the chances are very slim that the second bidder is going to get bond financing. But we have to allow the process to take its course. Thank you, Madam Speaker.
Thank you, Senator Pt.2. On the motion, Senator Barnes, you recognize.
Madam Speaker. Madam Speaker, as I'm listening to this analogy, and I don't know, we're beating a dead horse. I don't know where I'm at with this, and I'm going to tell you, is because based on that shall and may and the implications that we're opening, I guess, more chances for bidder one to go through. And there was an analogy using a cup and not knowing that, okay, this cup may be 69 million, but what about, we're not sure that the other two cups may be more? I'm under the impression, based on what was provided to us, that the other two offers may be cheaper. I don't know. Yes, he is right. I don't know. But let me tell you something. As this procedure has been going on for so many months and failed attempts and the reason why we're here today, I'm going to share with you that this process has to move forward. And we've had this mechanic in place in past proposals. So why are we giving an opportunity again to open or give a chance again? Why can't we just, okay, we're looking at this, let's do it, get it over with, let's move forward. All of us in here want to see JFK moved. But let me tell you, if we're going to keep assuming and assuming and assuming and giving chances, then Jesus, Lord, we're not going to get anywhere. This provision shall, may giving the opportunity to give the chances for the agencies to work things all over again. I'm telling you, let's work the process. Like my good colleague from Chalampago, Manila talked about, it's already in place. Let's move forward, let's work it. I object to the amendment.
There's objections, or those who are in favor of the amendment? Yes, you may close.
Thank you, Madam Speaker. Madam Speaker, I respect what's been said. However, I think we've lost sight of the very reason why we're here. The very reason why we are here today to address this bill is because we're the ones, as a body, that created the process that right now is at a standstill. In other words, we are the ones who required that there be tax-exempt bonds as part of the financing, and for that to happen, there has to be an unqualified opinion from bond counsel to be able to make that happen. That's the process. I mean, if we want the process to go forward, then that's what we should allow bond counsel to do, and that's the reason why there was an introduction by the governor to make it, to allow it to go forward.
Madam Counsel, point of information.
Please state your point of information.
Public Law 29-114 was the law that was enacted, that mandated to start this whole process to construct JFK. In Section 58A-108, use of tax-exempt funds for financing reads, to minimize the financing cost to the education agency, financing utilized by the contractor to fund the design and construction of an education facility shall be through tax-exempt obligations or other financial instruments, provided such financing is available at interest rates determined by the education agency to be reasonable and competitive. Alternatively, the contractor may use an alternative method of financing. So the law did not limit the contractor to just a tax-exempt bond. But if you can find something equally good, that will work also. That's why it said or.
Madam Speaker?
Thank you very much, Senator Ada.
Even that is arguable. Because if we go back to that, and it says basically shall be through tax-exempt obligations or other financial instruments, does the description of tax-exempt apply just to tax-exempt obligations, or does it also apply to financial instruments, tax-exempt financial instruments? Now, what has been determined is that one of the companies was ranked number 1. Their method of financing, which is totally allowed by this, is tax-exempt obligations, tax-exempt bonds. To be able to do that, since they were ranked number 1, as was explained to us, the government of Guam, through its agent GITA, has to go side by side to the bond market. And to be able to be successful in getting the tax-exempt bonds, right? And again, we're talking about the number 1 rank. Before we go on to the next, we go to the number 1 rank. Give them the opportunity to do it. That is why we're here. Because again, it has been a process. We have allowed the process to go forward. There was a ranking. Regardless of who it was, there was a ranking. The number 1 ranker, basically, we're going to go for tax-exempt bonds because we all know, and again, I wanted to address this also as part of my closing, that when you start going down the road of tax-exempt bonds, those are probably the lowest interest rates we're going to get as opposed to private financing. So again, we have not let the process fulfill itself in terms of addressing the needs of the number 1 ranked offerer. Now, I agree that after that, according to what was said yesterday, that the Director of Public Works, as a procurement officer, can either then look after to the next offeror, if it doesn't pan out for offeror number 1, right? And say, okay, let's take a look at your packet, or it could cancel it and start the whole process over again. Now, again, it's all debatable right now, so it's nothing, I don't think that anybody can say, right, that for sure this is set in stone, because obviously it's not. We've come to this point where the process has stalled, and it's because of something that we as a legislature has basically created, allowed it to happen, to go for tax-exempt bond financing after the fact that those companies, those offerers were ranked. The process went on. They said, yes, it may have not been perfect, but it was all within accordance of law. There was no wrongdoing, there was no ill intent, there was no fraud, or anything. It was just the process that went on. We gave them a very short time window to be able to develop this, 30 days. That's what happened. And we're here months and months and months later. And the argument I was putting out is that we are the ones who allowed this to happen because that's exactly what we required. So now to say that we're stopping this process just is not a real argument because we have not even let the process, we have not even got to the point to let the process continue for the number one ranked offerer in this case. One of my colleagues said, well, you know, the reason why we are here is because of DPW's inability to move forward. That's an incorrect statement. The reason why we're not able to move forward at this point, I have not been able to move forward because of the protests that have been filed. That has taken months and months and months to be able to resolve. And now we're saying, well, even past all that protest, now there's one more hoop we got to jump through. Because there has been only one other instance in which we have allowed this kind of financing to take place, and that is when we allowed for the 4 leaseback schools that have been built recently. The problem is, or at least the situation is that during that procurement process and during that whole financing process, there was no protest. However, in this one, which as we all understand is exactly the same methodology as those 4, there was a protest, which now brings to light what we need to do to overcome the protest, to overcome the obstacle that is in our way. And the obstacle is in the way right now is the lack of basically a unqualified opinion from bond legal counsel. That's the only reason why we're here, is to be able to have the bond legal counsel put out an unqualified opinion so that the process can then proceed forward. That's exactly why we're here. It's the only reason why we're here. Now the matter is, what is the solution to be able to allow that to happen? Is this so detrimental, the shall versus the may in terms of this amendment? No, but again, now we're changing the name of the game also in that whole process. Whereas before, the Director of Public Works had the discretionary ability to say, okay, after this it's not working, then I can go down and take a look at the next rank guy, or we can just call this off because it may not even be feasible to go down this road anymore. He has that ability right now. Now we're taking it away from him. Now it's a matter of people are basically saying, this guy's evil. He has not demonstrated any reason for us to suspect that he is acting against our best interest as a government. He has given us no reason, and yet we're suspecting it. We're assuming it, that there are some underlying motives right now, and that's the reason why we haven't moved forward. That is not the case. That is not the truth. Another one of my colleagues said, well, okay, I want to address this. Let's just let the process go forward. Let's follow the processes. Well, that's exactly what we're trying to do. Like I said, the process is we gave them the ability to go to the bond market. The requirement is the government needs to stand side by side to be able to affirm the partnership in this going forward with the number one offerer to go to the bond market. The only requirement the bond market has now, like I said earlier, is to have an unqualified opinion. That's part of the process. So if they're arguing that why are we stalling the process, well, we're stalling it right now by not agreeing to let this process go forward. It's not because of my little amendment to change the shall to may, because actually may is exactly what it is. That's the law right now. There was another of my colleagues who said, well, who's to know that the next offerer might not come along with a new financing without going to the bond market? Well, we've heard the councils yesterday say, well, one of the other offerers, aside from the number one ranked, his method of financing was going through the USDA, Department of Agriculture. But even that would have required an opinion from our bond counsel, which would actually put us back in the same situation here right now. That was in the packet. That was the methodology of financing. So again, I'm not sure what we're talking about of new financing, because if what the bond counsel and our attorney general under oath stated is true, which we would have to believe them since they did it under oath, and we have to acknowledge that the attorney general is basically acting on the best behalf of the people of Guam, then why would he come out and say that every single, in his best opinion, every single one of those offerers would have required the same thing that offerer number one is requiring right now, which is an unqualified legal opinion from bond counsel. So the whole argument of somebody coming in and saying right now, well, we have a whole new way to finance this thing, that's outside the scope of what was bid, of what was in the RFP. That is not relevant at this point. And besides, because there has been no disclosure of what the contents of those offers were, of what those packets were, we don't know. So if we really want to let the process proceed, we have to remain objective in terms of why we are here. We are here to see if we can allow bond counsel the ability, or figure out a way for bond counsel to have the ability to issue an unqualified opinion so the bond market will feel comfortable that the methodology of financing is secure. Or if anything, at least that the contract that we entered into is valid and binding. So again, all these arguments are red herring arguments. I understand the passion because I think everybody's just getting frustrated that we want to move forward. We all want to see JFK built. But let's not mix the arguments with theories and assumptions and presumptions of what we don't even know. What we know is that we are here to allow and find out and give the ability of bond legal counsel the ability to go and issue an unqualified opinion so that the number one ranked company can go and get some financing. And the other argument I want to make in terms of what if the second rank offerer has private financing in place, we all know. We've discussed this in the past with other financing measures that we've had when it comes to GPA, GWA, and whatnot, that when you talk about private financing versus tax-exempt financing, bonds, private financing is definitely going to be more expensive. Definitely. Is that going to be in the best interest of our people? Just because we're not allowing the number one rank to go and get to get a tax-exempt bonds, now we're going to let it go pass on to the guy who we assume might have some private financing, and we don't even know what the interest rate on that is. But we can be well assured that it's definitely going to be higher than a tax-exempt bond. So again, these arguments to me don't hold water. They don't hold weight. And then we're coming to this all about, and all these arguments are being put about, all on this one little amendment that I'm trying to make. And that's basically to restore what is actually in the purview of the procuring officer. The ability to have the discretion to proceed on to the next bidder should the first one fail, or the ability to perhaps call the whole thing off and start all over again. That's his ability right now under the procurement laws or rules, right? And why are we taking it away? So if you want to talk about consistency and allowing the procedure to go on, the process to go on, then let's do exactly that. Let's not assume that all these guys who appeared before us are bad guys, that they are working against us in the best interest of against the best interest of the government. Let's go ahead and allow them to proceed, because we as a body, as a legislative body, are the ones who mandated that that was going to happen. I don't understand. This is not a difficult argument. We make it a lot more difficult than it really is. Thank you, Madam Speaker.
Thank you very much, Senator Espaldon. Since there is an objection, all those in favor, please raise your hand. The amendment fails. On the amendment that has been amended, anyone in favor? All those in favor? There is an objection, so all those in favor then with the amendment that has been amended? Yes, the change has been to 90 days which pass, and the words from selection is from enactment of this act that adds this subsection on that amendment that has been amended. Are there any objections? There is an objection. Therefore, how many then are in favor? Please raise your hand. Yes. Yes, the Palacios amendment. Amendment fails. Amendment number 4.
Speaker Wampat, you're recognized on the amendment.
Thank you very much.
On a
Madam
new
Speaker.
amendment.
The amendment I would like to proffer this afternoon actually is to add a new section 3, which is section 58A 109 of chapter 58A of Title 5 Guam Code annotated, is hereby amended to read as follows. And what I'd like to remind my colleagues is the section here that is actually provided here is in Public Law 29-114. The amendment, however, to that particular language in which it actually would call, or the pledging of the Section 30 monies of about $9.8 million, is to actually set a cap. The cap was an issue that the Office of the Public Auditor had questioned and wondered why that there was none left. And so what I'm actually trying to do here, and in working also with GITA, that based on where they are right now in the negotiations, is that instead that it shall be limited to $6.9 million, and that the remainder of the funds from the existing lien or supra shall be used for the expansion of Okudu High School, to fund the expansion of classrooms, to accommodate the overcrowding, bathroom facilities at all outdoor sports fields, additional bathrooms required by the public health due to increase of student population, solar panels, the culinary arts building, signalization, track and field with proper turf, so we track and field, track with proper turf, and other projects needed to facilitate the expansion to accommodate the increase in student population. So that's my amendment. Thank you, Madam Speaker.
On the main motion, if there are anyone who wishes to speak, if not, if there's no objections. What? Senator Espaldon, Jimmy Espaldon, you're recognized on the main amendment. Jeez.
Thank you. Actually, I rise in support of this amendment. I remember back in the day when we were trying to address the JFK situation, and there was an emergency session called just for that particular issue. And however, at that time, there were several other CIP projects that were added on to that list. And I was the one who moved to strike all those other CIP projects from being discussed, because again, the call of the speaker was to address the JFK issue. And I thought that to address the other CIP issues was not germane to the declaration of an emergency. However, that is not to say that those other CIP projects were not necessary. And in fact, as time has moved forward, it became even more apparent to me that this amendment is necessary. Because in order for us to build the other projects that this government needs to serve our people well, in fact, in this case, to increase the size of Okudu High School so that it can accommodate more students, and it perhaps going to be one of the fastest growing neighborhoods on this island, we are going to need to preserve some of that money that was that was up to now dedicated just to the JFK project, which actually would have yielded more money than the JF project would have needed. Now we can actually take, through this amendment, some of the dedicated money that would go towards the repayment of any financing, which would now allow us to expand our needs at Okudu, which will again be one of the fastest growing communities in the next several years. So I am definitely in full support of this amendment. Thank you, Madam Speaker.
Thank you, Senator Espaldon. Anybody on the main motion? Senator Tenorio, you're recognized, and then Senator Calvo.
Thank you, Madam Speaker. Madam Speaker, again, consulting with bond counsel, Mr. Dirks, it is his opinion that it would be in the best interest of the legislature, and I'm willing to go along with the Speaker on the amendment here and the adding of a new Section 3 with the pledge of Section 30 revenue with an amendment which I'm willing to copy and provide to you, which strikes on the second line after the word back. So on the second line, when
on the amendment,
yes,
which is after.
So, let me go ahead and say the amendment. The amendment would be to strike the word may on the second line all the way down to the 8th line, which begins with the word 100. I'm sorry, to the 7th line, which begins with and strike all the way to the word until it says shall. Leave shall be limited to. So you'll strike from the word may be secured, so it'll say then, rental payments under the lease and the lease back shall be limited to, and then all the additive language that she's inserted, which is $6,900,000 per year during the lease back period, and again continuing with the additive language. So you're striking all the words on the second line beginning with may, all the way to the 7th line that says and. And the bond counsel's advice, again, which I try to consult with for the interest of making sure that we're trying to work in good faith here to make legislation which will be effective in building the John F. Kennedy High School for our students on our island, is to not cite the section which is already in the citation 58A109, because Section 30 funds are not, in fact, used in this particular case. So I moved the amendment in an effort to try to, again, in every amendment that we've been dealing with, in working in good faith with the bond counsel's advice, because that is why we have asked him to be here, to give us direction and give us assistance on things which are highly technical and require the expertise of someone who clearly has vast more experience in this than any member of this body, in my opinion.
Thank you. Thank you, Senator Tenorio. Anyone else? Senator Calvo, you're recognized. Oh, wait, on the amendment to the amendment? Okay, if there are any objections to that deletion, Senator Speaker Wampat, you're recognized on the amendment to the amendment.
Thank you very much, Madam Speaker. Madam Speaker, the only reason why I decided to use the exact same language in the section that I've quoted here is because this is currently public law. And I had asked that question, yes, of bond counsel, exactly what language was he actually using in this law to determine exactly what we're going to be pledging and what we're going to be using as a funding source. And his comment, or his answer to that, was that then it would actually come from, in this case, the general fund. That means whatever revenues that we've collected, then the government will have to put aside then, at this point, $9.8 million. And there's, at least in my understanding and reading what's in the legislation, that language is not here in this bill. And to keep this language clean, and that's the reason why I decided to do that, because then you need to go even further than if you want to then remove the title and then go back to the underscore amendment, then it addresses again Section 30. Bond counsel seems to be of the opinion that based on Public Law 29-114, that he could determine exactly what funding source it is that he feels that the government of Guam then should use. Therefore, then who are we in the legislature then to make that determination when the power of the purse lies with this legislature? It is this legislature who determines what funding source is to be used and to commit and to appropriate. So I posed that question to my colleagues, And
So-
because of that, then.
That's an objection.
I'm not, yes. it is.
Okay, there is an objection to Senator Tenorio's amendment. Senator Calvo on the Tenorio amendment.
Yeah, thank you very much, Madam Speaker. Madam Speaker, if you can recall the discussions yesterday too and how this has moved forward, some of the problems were, again, trying to move forward in this leaseback method of development, yet keeping under the debt ceiling that has been imposed for our government. And that is why actually the administration working with bond counsel found the necessary wiggle room through the may pledge. It wasn't a shall. And with that, they were able to move forward in showing that this would not add to the debt ceiling of the government of Guam. And that language may allow them not to be forced to use Section 30 money. The concern of the use of Section 30 money, then, it would be construed as, because it is part of the general fund, then it would be, again, applied to the debt ceiling of the government of Guam. So I think what the earlier senator who proposed the amendment was trying to just keep in line with what has been the game plan. It wasn't to go against the wishes of the legislature. The legislature actually gave this flexibility for the pledging of Section 30 revenue. So this one really is more, and again, we're already going on that path. This would just, again, clean up the language so that the reference to the Section 30 would not be applied to it. There are other references, I'm sure, in the law that shows the application of Section 30 revenue, but be that as it may, we've already set on the course. And whether we have this amendment in that strikes out or we don't, the path has already been set. And I just want to, for clarity to everybody here, whether it's here or not, the path has long been set. So there's not much to argue on. But anyway, thank you very much, Madam Speaker. That's just my 2 cents worth.
Okay. Thank you, Senator Eddie Calvo. On the Tenorio amendment, is there anyone else who wishes to speak? Senator Taitigui, do you wish to speak on the other? Okay. There has been an objection to the Tenorio amendment to the amendment, so all those in favor of the Tenorio amendment, please raise your hands. 3, 4. Motion fails. We are now back on the Speaker Wampat amendment, and as before you, Senator Taitigui, I'm going to recognize you on the main amendment.
Thank you, Madam Speaker. Madam Speaker, I stand in support of Madam Speaker's amendment as well. And, but, you know, we have to consider this, to my colleagues. Not taking away, of course, the urgency of JFK and the construction of JFK to be started right away. But one thing we must remember as a body is that we have obligations not only to JFK, but to all students in our entire public school system. This is why, you know, the decision we make, we must benefit not only, it must benefit not only the students of JFK, but the whole community and to our island in general. We must not forget also Simon Sanchez, Southern High, and GW that are still struggling with the overcrowded issues. I also know of other elementary and middle schools that are in dire need of renovation and upgrade. So, Madam Speaker, I stand in full support of the Speaker's amendment to the bill. Thank you.
Thank you, Senator Taitigui. Senator Calvo, you want to speak on the main amendment?
Yeah, just
Please
I
do.
want, for the record, I am for the amendment as
Okay.
proffered by the Speaker.
Okay, thank you. Appreciate it, Senator Calvo. Are there anyone else wishing to speak on the main amendment? That's right. I will give you the opportunity to speak on the main amendment.
Thank you. I appreciate the opportunity, Madam Speaker. Madam Speaker, I too rise in support of the amendment. we may not always agree. We may not always go along with bond counsel, but we do agree on one thing. We have to help JFK. We have to help all of our students in our school system. This, hopefully, I really hope, bridges the gap. There are not a lot of things that I agree with respect to the previous amendments, and I've articulated why. Maybe this is the one. And I applaud the speaker for moving this amendment. And notwithstanding the objection or the failure of my amendment previous, I will too rise in support of this amendment. Thank you.
Thank you. So, thank you, Senator Tenorio. Are there anyone else wishing to speak on the Speaker Wampat's amendment? If not, I'm going to ask Speaker Wampat, please close on your main amendment.
Thank you very much, Madam Speaker, and I thank my colleague, for their statements and support. And actually, Madam Speaker, what I'd like to relay to you and to our members here and the listening audience, because I know it has been some time, because as the law had indicated, it is Public Law 29, which means then that it was in the 29th Guam Legislature when this had passed. And one of the things that I normally do, it's a course of making sure that whatever legislation we're going to introduce, that it should be able to get the support of members of the community, that we will also be able to make sure that it is going to benefit the community. And at the time when this whole situation started with the closure of the school by our then Attorney General, and after 1 year of our children being in a double session, we knew that wasn't the best situation at all, and we needed to find a home for them, and a temporary home at that, until such time then that the permanent structure is built. And I'd like to let everyone know as well that although sometimes we're just saying, oh my gosh, we're not really giving them a home. They do have a home. It's a temporary home, just like the way any one of us, should we find our homes insufficient to use at the time if it's destroyed by the typhoon. Similarly to what we had to do in my family when our house was blown down after Typhoon Pamela, we had to all move in to a one-bedroom apartment. And that's for a family of 8. But we had no choice, and we made do with what we did, because that was, the emergency situation. And when we proffered this bill, the bill went forward, and that was Bill 363. And the bill actually came to the floor, and it was heard publicly, and it was called the Education Facility Bill, because it was to provide other capital improvement projects for our educational institutions. It had a middle school, it had a high school, it had a northern high school, it had JFK, it had a center, a student center for Guam Community College, it had a student center for the University of Guam. So it was designed specifically, for those educational institutions. Now, granted that there may be 6 CIPs, it doesn't necessarily mean that all 6 may be carried on. But it was sending a policy by this legislature that we were making education, yes, our priority, and using a funding source that normally others would love to use elsewhere. And I remind everybody that even with the solid waste management loan right now that is, so to speak, sitting in limbo versus the other amount in the U.S. Department of Agriculture loan as well, quickly, as soon as we got knowledge of that, how many bills were proffered to be able to reprogram those monies for whatever every single one of us had our priorities. But this was the priority of the 29th Guam Legislature, to do this. Unfortunately, yes, and I thank Senator Espaldon for, claiming, of course, that he was the one who made the amendment to delete all the other projects. But when we made the deletion, we didn't make the deletion by placing the cap, because we all understood that we were going to come back eventually and put in these other projects. But what had spooked the legislature at that time was the 2 loans, our applications for a loan that went out, and for fear that then we might then exceed our debt ceiling, we did the prudent thing, and that was to delete it. And he was able to get full support of the legislature, so he's not to blame alone because he couldn't do it alone. It would need the rest of the body here. We need at least 8 to pass it. And at that time, it wasn't 8. It was supported unanimously. So yes, we're all part of that. So, Madam Speaker, here we are now at this juncture and wanting to make sure, because of the overcrowding in the northern side, that this is not to replace JFK, that this other school that now we're going to expand, that we wanted to build a northern school. We listened to the community, the families who live there, and felt that they didn't want to congest the area any further than what it is currently experiencing. So we worked it. And this is exactly what it is that we needed to do. And then we worked also with Gita to make sure that then we're not jeopardizing JFK, and at the same time we would be able to meet again the needs of our children, where the growth and population is actually taking place in the north. So that's the history. And it's important we always know the history. And that's why I'm saying that it's important that, especially for like our newest, youngest member here, to know that history too, so he can move forward again. So I hope, Madam Speaker, then that this amendment will pass. Thank you very much.
Thank you, Madam Speaker. On the amendment, all those, is there any objections to this amendment? If not, motion carries. Speaker, I was going to ask you you were on a roll.
So we have amendment number 5. I think you took, okay. Yes, amendment number 5, Senator Barnes, you're recognized.
Si Dios masi, Madam Speaker. Madam Speaker, I was going to ask you to share in this amendment because you were on a roll here. I hope that my colleagues look at this amendment and favor that. I'm just going to cut to the chase, Madam Speaker. I have a proposed amendment here in section 4 is hereby added to read as follows. Section 4, section 58A 108 of chapter 58A of Title 5 GCA is hereby amended to read subsection 58A 108, use of tax-exempt bonds for financing to minimize the financing costs to the education agency, financing utilized by the contractor to fund the design and construction of an educational facility shall be through a tax-exempt obligations or other financial instruments, provided that such financing is available at an interest rate of no more than 8.25%, Madam Speaker. And then it deletes determined by the educational agency, and then it goes on as what it states in the bill. This is a real simple amendment.
Yes. On the amendment, I recognize Senator Calvo.
No objection.
You were young. Okay,
No,
so sorry. Senator Tenorio.
Madam Speaker, I want to again give the input of our bond counsel with respect to this, and as well as our GITA officials who are saying that 8.75 is an achievable and realistic interest level. We have allowed up to even 10% for cost of living allowance bond that we've gone to the market before. And I, of course, I asked them, well, if the bond, if the purchasers of the bond see, for example, that is permissive at 8.75, will they push the envelope? And they said that's not really how it works, and it's really not how the system will, in effect, operate when they go to bond market. They are going to push for the most realistic and the most advantageous for our people, and of course the government of Guam, as anyone is trying to achieve the lowest possible interest rate. But I don't want to set it up for failure at the same time by setting an artificially low interest rate which is not achievable, and then effectively killing the process of being able to obtain those bonds. And I think they're called certificates of participation in this case. But I don't think that financing can be achieved if it's a possibility, if there's a chance that we can't get financing with, what is it, 5 points from 8.25 to 8.75, and we're effectively killing the process or the chances of it for half a percentage point. I'm really reluctant to do that. I really think that we need to give the greatest flexibility possible. I want to get the lowest interest rate, but I don't want to set this up for failure. I don't want to go down a road that says 8.25 is not achievable, which is not a certainty, but based on the input of GITA as well as our bond counsel, there is a chance that it may not be sold for that amount. So with that, I'm going to recommend, and I move now to amend the amendment to 8.75 and adjust the Fino English in the previous section to the corresponding numbers, which will be 8, let me get my glasses, no more than 8 3/4%. Thank you, Madam Speaker.
On the Tenorio Amendment, Senator Guthridge, you're recognized.
Speaker, I rise to object to the amendment. I think that the intent is well-meaning. However, the cost would be much too high to allow a ceiling as high as that. Thank you. Right now, the bond market is very, very attractive, and I don't think this government should be foolish in authorizing such a high rate of interest. Thank you.
On the Tenorio Amendment, any other speakers? There is an objection. All in favor of the Tenorio Amendment, please raise your hand. Amendment failed. We've exhausted the list of the amendments on the floor. Oh, wait, I'm so sorry, you're right. Oh, yes, so you're right, on the main. Terribly sorry, you're right. You may close, Senator Barnes, on the... Would you like to close or recall for the vote?
Thank you, Madam Speaker. On the main amendment, you know what? We look at the bond market now. We look at what has been passed on the recent bond that has just been passed. It is very attractive. It's gone down to 5.5. I may be mistaken, but I know that the cap was much lower on the last bond process that we did, and I'm saying that this is fair. I've been very objective to this, and I'm hoping that my colleagues just consider this. So please, thank you. I ask them that they support this effort.
On the amendment, are there any objections? There is an objection, so therefore, all those in favor of the main amendment, please raise your hand. The amendment fails. Since we've exhausted all the amendments on the floor, you do have an amendment, do you have?
Very simple. Madam Speaker, again, in consultation with the legal counsel, it has been advised, in order to make it clear, with respect to Section 2, I'm moving to strike the word repealed and reenacted, because all the language there that has been added and changed is in fact an amendment, and to be clear, that this is in fact an amendment, not a complete rewrite, to change the language to say, is hereby amended to read, and strike repealed and reenacted. That's it, yeah. Section 2. And the title. Yeah, that's the only section.
So the amendment then is on the title, an act to amend rather than repeal and reenact, and then on page 2, line 5, to delete repealed and reenacted to, and add the words amended to read. Yes. So are there any objections? No objections, so ordered. Are there any other amendments? Senator Espaldon, you're recognized for an amendment.
Madam Speaker, there is a potential amendment, but if I could just ask a 1-minute recess to perhaps vet it out in my mind, because I know that there is some concern in terms amongst all our colleagues in terms of using or basically putting the crux of what we're trying to do to get an unqualified opinion, right, for our bond counsel by almost waiving the procurement law. And I know there's a real concern amongst many of us here. But to be able to move forward for the JFK issue, to make sure that it does get built, I would like to take a minute perhaps and we can consult on perhaps the resolution of the concern of basically taking the procurement law and waiving it in this particular case, if I may. 1 minute, Madam Speaker, is all I'm asking. That will possibly result in amendment. If it cannot be resolved in the 1 minute, then we will go on as you proceed, Madam Speaker.
We would take a 1 minute recess.
Thank you.
Legislature is back in session. I recognize Senator Espaldon. I understand you have a new amendment.
Yes, thank you, Madam Speaker. Madam Speaker, I believe the amendment that I have has been passed out to all my colleagues. And in essence, it would be under subsection B of Section 2. As we all note, it's similar to an amendment to a degree in which after the word terms, and let me just read what it will read. Upon the execution and delivery of the education agency of the contract, the lease back, and any other agreements relating to the design, construction, maintenance, and financing of the education facility, the contract, lease back, and such other agreements shall be valid and binding obligations of the education agency, enforceable in accordance with their respective terms, comma, and then we delete all the wording that is presently there right now and add at the end, after facility, and there shall be no power to terminate or declare null and void the contract, lease back, or such other agreement pursuant to Section 5452 of Title V GCA. In essence, Madam Speaker, this basically really focuses in on the limitations of remedy, and no longer is the whole procurement law at risk of being included in this legislation. And I think there would be a greater comfort level amongst all of us that we're no longer striking or waiving the procurement law in totality just to satisfy the JFK situation. We are just basically taking one section, which is basically addressing the remedies after the award of a contract, and one section only, which then would be able to help us fulfill the mission that we are on, and that's to build the new JFK. Thank you, Madam Speaker.
Thank you very much, Senator Espaldon. So on the amendment, then, there are no objections, so ordered. The second amendment, Senator Palacios, it was your amendment. Where are we? Should we give it to Senator Palacios? Okay. Okay, so, all right, Senator Tenorio, then you recognize.
Madam Speaker, using the previous amendment, which was crafted by Senator Palacios, I'd like to offer the following amendment, which will say subsection C is added to Section 2 to read as follows. D, the contractor selected through subsection A of 58A 105 shall be deemed disqualified if funding is not secured within 90 calendar days from enactment of this act that adds this subsection, period. If funding is not secured as required by this subsection, the Department of Public Works shall proceed in accordance with, Madam Speaker, would you give me the citation? Oh, in accordance with Section 3114 L4 of Chapter 3 of Division 4 of Title 2 of GAR.
So, okay, so it's subsection D. The contractor selected through subsection A of Section 58A 105 shall be deemed disqualified if funding is not secured within 90 days from 90 days from enactment of this act that adds this subsection, period. If funding is not secured as required by this subsection, the Department of Public Works shall proceed as provided in subsection 3114 L parenthesis 4 parenthesis of Chapter 3 of Division 4 of Title 2 of GAR.
Correct.
Does everyone have a copy of that and you're able to follow along? The clerks. Senator Ada?
I think I have a problem with that, because if you actually take a look at that section, there's that permissive language in there. So if we say that he shall proceed as provided in section 3114, that particular section then says that the director may go to the next guy, or he may terminate negotiations and start all over again. And so, we wanted, the argument from the very beginning was stay the course and let's play this out because we're almost there. But if we word it the way it was being suggested, then we're really right back to that permissiveness, and we're not very well. It may very well be that when that first guy, if the first guy gets disqualified, we terminate and we start all over again.
We're going to take a minute recess. The legislature is back in session. Senator Tenorio, you're recognized.
Madam Speaker, reiterating my amendment, this will add a new section C to section 2, which states, the contractor selected through subsection A of 58A105 shall be deemed disqualified if funding is not secured within 90 calendar days from enactment of this act that adds this subsection, period. If funding is not secured as required by this subsection, the Department of Public Works shall
Proceed.
proceed in accordance with,
Proceed
shall
with
proceed
the next.
as provided in 3114 L4, Chapter 3, Division 4 of Title 2 GAR.
Okay, let me see. So then, on the fourth line where it says shall proceed as provided in, and then the rest of the words. So we strike out with the next best qualified offer. Okay, on that amendment then, are there any objections? No objections? So ordered.
Madam Speaker,
Yes, Senator.
move that we
Antonelli.
proceed to the voting file to vote on Bill 15-S.
A minute recess. Back in session, I recognize Senator Tina Rose Munya Barnes.
Senator Citos Masi, Madam Speaker. Madam Speaker, I move for reconsideration on a previous amendment that I had proffered earlier, and it is the exact amendment with the exception of changing the percentage rate instead of at 8.25% as a medium.
So on that motion to reconsider without any objections, so ordered.
Thank you again, Madam Speaker. I'm sorry for jumping the gun. I changed that interest rate of no more than 8.5%.
On that motion, no objections, so ordered. The legislature is back in session. I recognize Senator Gothard for a motion.
Thank you, Madam Speaker. Madam Speaker, I'd like to move that Bill number 1 be distributed to all the senators with all the amendments, and that the senators be able to act on the bill without engrossment, with the understanding that the Assistant Legal Counsel shall make all the necessary technical changes as required.
So the motion then is to vote on the bill without engrossment?
Yes, Madam Speaker. After the senators have copies. Bill number 1.
15S.
Right, 15S.
I'm giving you time to think. Are there any objections? No objections, and so ordered. Senator Gutherds, can you also make a motion then now to send the unengrossed bill down to the voting file?
Yes, Madam Speaker, I'd like to move to send unengrossed bill number 1-5-S down to the voting file for action.
And on that motion, without any objections, so ordered. The legislature is back in session. We are in the voting file, but I'd like to reconfirm the motion that legal counsel will make technical corrections, and we are voting on a non-engrossed bill, but you do have the bill with all the amendments intact. Okay. So we are now in the voting file. Bill number 15-S.
Bill number 15-S as amended on the floor, introduced by Committee on Rules, Natural Resources, and Federal Foreign and Micronesian Affairs by request of Himagala and Guahan in accordance with the Organic Act of Guam. An act to amend Section 58A 105 of Chapter 58A of Title 5 Guam Code annotated.
Roll call.
Senator Ada. Yes. Senator Tony Ada.
Yes.
Senator Agun. Senator Blas.
Yes.
Senator Calvo.
Aye.
Senator Cruz. Senator Spaldon.
Yes.
Senator Guthertz.
Yes.
Senator Munya Barnes. Senator Palacios.
Pass.
Senator Pangilinan. Senator Respicio. Senator Taitagui.
Yes.
Senator Tenorio.
Amen.
Speaker Wampet.
Yes.
Senator Munya Barnes.
Yes.
Senator Palacios.
Congratulations, everybody.
Bill number 15-S received 11 yeas, 4 excused absence. Bill number 15-S is duly passed by this body. A motion, Senator Guthertz.
Speaker, I move that we adjourn subject to the call of the Speaker.
On the motion without an objection, we are adjourned subject to the call of the Speaker.